We'll now proceed to the second case on the oral argument calendar, Syngenta Seeds versus County of Kauai.
May it please the Court, David Minkin, along with Jesse Smith, on behalf of County of Kauai. I will reserve 2 minutes for my closing while I'm splitting my time with the intervener. So I'll go about a little over 5 minutes, then defer to Mr. Achitoff on behalf of the intervener. Thank you, sir. Good morning, Your Honors. What we have here is the District Court's erroneous conclusion that Ordinance 960 is preempted by state law. What's significant is that the companies, the plaintiffs, initially sued to invalidate the statute based upon federal preemption as well as state preemption. The hearing determined that there was no federal preemption. Afterwards, the court then made a determination that there was implied state preemption. One of our issues, and it's not just a ploy, is that once the federal preemption issue was disposed of, this matter should have been turned over via certified question to the Hawaii Supreme Court, because it's an important issue for the entire state of Hawaii, as you see by the calendar today. It is not just the County of Kauai, it's the County of Maui, and it's the Big Island, the County of Hawaii. That issue regarding whether it was something appropriate, whether it was preempted by state law, is something that the Hawaii Supreme Court, the district court, should have delegated it and certified the question over there. Why is, but I'm going to go back to that momentarily. What do we have? Why was it erroneous? Because the district court made a determination that Ordinance 960 conflicted with the state statutes. It did not. The erroneous conclusion that the state regulations created a comprehensive mechanism for regulating pesticides and evidence that the legislature's intent that the state law be both uniform and exclusive. That's not the case. We had a statute, an agricultural statute, that covered some areas. What did it cover? It covered labeling and directions for use. It covered reports. And somehow the fact that the state agricultural statute covered these areas but could not conflict with federal law, FIFRA under Mortier, this district court made a determination that it was comprehensive, that it was uniform, and that it was...
Correct me if I'm wrong, but the analysis regarding the pesticides was under one statutory scheme, and then the reporting was under another, right?
Correct.
All right. So, arguably, the district court could be correct on the pesticides and wrong on the reporting, or vice versa, right? It's not just one size fits all, right?
Correct. But our position is that the court looked at it, didn't go into great detail as it should have, and looked at what was the intent, what was done, where it was done, and the specifics. The appellees argue that, well, the case law is there, the court did what it needed to do. But as this court knows, in the Richardson case, there was a certified question. The case law had existed from prior cases, but what did the Richardson case show? The Richardson case showed that you needed to look beyond, you needed to look at legislative intent, you needed to look at exactly what was taking place, and not morphing it in and saying, well, because there's an issue with labeling and areas and then after the fact, but the county was doing something different. It wanted to do something prospective. It wanted to do something at the forefront, whereas what the state statute allowed was something after the fact, and that wasn't what the county was looking at. The county's authority was derived from its police powers under HRS 46-1.
Well, but if you look at the Hawaii pesticides law, it expressly states the legislative goal of uniformity if you look in HRS section 149A through 19 and HRS 149A-23. In light of those provisions, how can it be said that the state law does not disclose the legislative intent of the state's regulation of pesticides to be uniform or exclusive?
I believe that what's there, yes, the language is there, but if you look at it closely as to what was really being done and what was being sought by the county and the state at that level, there was delegation. There was an ability under the police powers and, more importantly, under the constitutional provision of the public trust doctrine that mandates, no matter what statutes exist, no matter what rules and regulations exist, and this is the Kauai Springs case, which I had the pleasure of arguing before the Hawaii Supreme Court, said that the counties have that duty and responsibility no matter what else, to protect its people, to protect its resources going forward. That's the issue. That's what's needed to be.
But what happens when that conflicts with the state law?
The constitutional provision?
Well, you're saying that what the county was trying to do, that they had an obligation to do it. Is that what you're arguing right
Correct.
now? All right. But I guess I'm kind of dovetailing with what Judge Callahan asked you, because it seems like the Hawaii pesticides law and then the rules that the State Department of Agriculture has enacted pursuant to it are pretty thorough when it comes to regulating these pesticides in Hawaii. And so wouldn't that thoroughness indicate that the legislature intended for this scheme to be comprehensive and exclusive? So I don't know if I'm asking the same question, but it's right around there.
I understand your question, and I don't believe that it shows that intent, because after Mortier, what we do know is that a number of states passed laws basically expressly preempting the municipalities from doing what Kauai wanted to do here. That failed here in Hawaii. The State Department of Agriculture pushed for that statute, and it did not pass. What does that tell us? The legislature wasn't willing to go that far. The legislature wasn't willing to preclude the local municipalities on each of the islands that have a unique circumstance to basically, under the public trust doctrine and police powers, take care of their own.
So you're saying Mortier supports your position?
Yes.
Okay, well, let me play the devil's advocate here with you. In Mortier, the Supreme Court concluded that FIFRA does not preempt state and local pesticides laws because FIFRA leaves substantial portions of the field vacant, including an affirmative permit scheme for the actual use of pesticides. Ordinance 960 provides for an affirmative permit scheme for the use of restricted pesticides, and it also regulates the sale, transportation, and disposal of pesticides. Why doesn't it follow that under Mortier's logic, Ordinance 960 fully occupies the field of pesticides regulation?
So I don't think that it does, because I don't think the state statute.
Well, I don't think so, but that's not. Can you get a little more specific on that?
I believe that the state statute doesn't encompass everything. It's not uniform. It's not thorough enough. It's not exclusive based upon the statute.
But based on what authority, or just your review? Because did somebody disagree with you on that?
Based upon the police powers, based upon the public trust doctrine, the constitutional provision. And I realize I've gone past my time, and I would now turn it over.
I have a question. Who's talking on reporting, the reporting part of it? Are you talking on that?
I would be, yes.
Okay. With the chief's permission,
Go ahead.
can I ask a question on that? Okay. The annual reporting requirement imposes an obligation on commercial growers of GE plants, the violation of which is subject to civil and criminal penalties. The requirement, thus, is coercive and substantively involves the county in the regulations of GE crops. Assuming that we were to find that Hawaii state law impliedly preempts a county ban on GE crops, wouldn't it follow that Ordinance 960's crop reporting requirement is also preempted?
And I'll defer to Mr. Achitoff because it's on the GE reporting. I'm sorry.
Oh, okay.
Mr. Achitoff, we'll give you plenty of time. Hold on.
I'll defer to him on that.
Okay. All right. I thought I was supposed to ask you.
Thank you.
Okay,
All right,
thanks.
Very good. Thanks for your argument. We'll give you some time for rebuttal. Now, Mr. Achitoff, nice to see you again.
May it please the court, Paul Achitoff appearing on behalf of defendants, interveners, Kamakani Ho'opono, Surfrider Foundation, and Pesticide Action Network North America. I'd like to reserve 2 minutes for rebuttal while I address what's been referred to as the reporting requirement, Ordinance 960's provision requiring annual disclosure of what genetically engineered crops have been grown and where they have been grown in general terms. And the provision was put there in the ordinance because of the potential for harms that this court in Center for Food Safety versus Vilsack acknowledged may occur as a result of growing genetically engineered crops, including transgenic contamination of non-genetically engineered crops. As my colleague, Mr. Minkin, pointed out,
Is this consistent, what you just said, with state policy? I mean, the purpose, I'm just trying to figure out, is the purpose of requiring annual public disclosures of GMA use? You just stated right now what you thought the reason was for pursuing that. And I'm trying to figure out, is that consistent with state policy?
I'm not aware of any state policy that it's inconsistent with. The state policy, if we want to look at, for example, the Constitution of Hawaii, Article 11, Section 3, provides the state shall conserve and protect agricultural lands, promote diversified agriculture, increase agricultural self-sufficiency. These are policies of the state, all of which are promoted by this provision.
Let me ask it more specifically, because it appears that the legislature has given the Department of Agriculture the authority to designate and restrict harmful plants. So I guess my question is, wouldn't the GMO disclosure requirements of the ordinance interfere with that and constitute a regulation of a plant that the department has not determined to be harmful and, potentially be in conflict?
First of all, there is no state policy or law or regulation that gives anybody a right to grow whatever they want, wherever they want, whenever they want. There is no such right. There is no state policy. You are certainly correct that the Department of Agriculture has the authority to designate or restrict harmful plants. The question here is that authority exclusive? Certainly the Department of Agriculture has broad authority, but broad authority is not by any means the same as exclusive authority.
It conflicts potentially with...
If the Department of Agriculture were to enact some regulation or do something that was inconsistent with this, then there might be an argument there. But there is no such action, there is no such regulation, there is nothing that this ordinance provision...
But doesn't it occupy the field?
No, it certainly does not occupy the field.
I guess so. I'm struggling with this too. We don't conference till after we come, so I don't know what my colleagues think. We don't make a decision till after we hear oral argument, and we don't always agree. But that being said, let's just assume that if the court were to find, and this is hypothetical, that regarding the pesticides you lose, all right, but then we look to the reporting. Isn't that just putting your nose under a tent where you can't do anything anyway? I mean, it just seems like, okay, so what are you going to do with these reports? Is that just allowing you what you can't do through the front door, coming through the back door, and then you're going to try to regulate areas that if we were to say that you can't?
All this provision does is require someone no one is being prohibited from growing anything.
Okay, but if you don't like the reports, then you're going to fine them for not liking the reports.
That's not what the ordinance says. The ordinance just...
What if you don't think it's complete? Then you're going to set up a whole committee that looks at reports and say, well, I don't think it's complete. We're going on the property, and I don't think you're reporting accurately. What?
With due respect, that provision, if it were to exist, is not the provision that's in the ordinance. It's not before the court. All we have is a very simple provision that says we want to know what you grew last year and where you grew it. That's all. And there is nothing in Hawaii law or policy or regulations that in any way suggests that this conflicts with any right that anybody has.
What do you do with that information?
That information would be useful, for example, if there were a genetically engineered corn that was disclosed to be grown in a certain general area. Now, corn is wind pollinated, and it can pollinate other corn at substantial distances, depending on wind conditions. I might be a farmer of organic or simply conventional non-genetically engineered corn, and I want to know, can I grow my corn here without the concern for transgenic contamination that may have an economic impact on me because my clients, my customers don't want genetically engineered corn? That's what it would do. And it does not in any way impair the ability of the genetically engineered corn grower to grow what he or she wants wherever he wants.
So turning to the pesticides provision of the state law, why don't you describe why you don't think that the state law occupies the field in terms of pesticide regulation?
Well, it doesn't cover what it is not comprehensive, and it is not exclusive. The point was made that the legislative history refers to the objective of making the law uniform. But as the Hawaii Supreme Court said clearly in the Hurup case, a law can be comprehensive and uniform and yet still not exclusive. And for implied preemption, the critical determination to be made is that the legislature clearly intended that the state law be the exclusive legislation applicable to the relevant subject matter. So mere uniformity is not the issue here. Nor would it be if the court were to find that it were even comprehensive. But it's not comprehensive. There's nothing in the pesticide law that governs any of the provisions in the ordinance, such as buffer zones. There simply isn't. That's why the ordinance was enacted, because the state law was not adequately protective. If the state wanted this to be exclusive, it had every opportunity to do so. As Mr. Minkin pointed out, there was a bill in front of the legislature specifically advocating express preemption of local regulation of pesticides, and the legislature declined to enact it at the very same time when, in the wake of the Mortier decision, dozens of states around the country did incorporate express preemption provisions into their pesticide law. So I believe that does give some indication of legislative intent not to be exclusive.
Any further questions? Thank you. We'll give you some time for rebuttal.
Thank you.
Good morning, Your Honors, and may it please the Court. I'm Chris Landau, and I'm here today to address the state preemption issues in this case, and I'll also be addressing those issues in the Big Island case, which is the next one. With me today at council table is Marjorie Bronster, who will address the certification issue and any other questions that the Court might have. I'd like to start out, if I could, with a general observation here. The issue in this case isn't whether pesticides and GE plants should be regulated or what those regulations should be. The only question here is the who does the regulating. Under current Hawaii law, the answer to that question is clear. It's the state, not the individual counties. There may be some separate federal law preemption issues, which we'll hear about in a moment, but as between the counties and the state, with respect to both pesticides and GE plants, the state has comprehensive schemes in place. And so there is what we would, in the federal context, call field preemption there. In Hawaii, it's more commonly called a comprehensive statutory scheme preemption. That is distinct under the Richardson case, which is the seminal Hawaii Supreme Court case that very clearly lays forth these legal standards, from conflict preemption. And I think a lot of the answers that you've heard this morning from the other side, when you've asked in various forms with respect to both pesticides and GE plants, why aren't these schemes, state schemes, comprehensive and in a sense preempt the field, you've heard answers along the lines of, well, there's no conflict. But that, of course, is conflict preemption. That's not comprehensive statutory scheme or field preemption. So I'd really like to address both of those areas.
So do you concede then that there's no conflict preemption?
No, there actually is conflict preemption of some specific points. In fact, there is conflict preemption, let's say, with respect to testing.
Let's just talk about that for a little bit,
Okay.
if you don't mind, and then I understand the occupy the field argument.
Is broader.
Yes. But unlike the Maui and Hawaii County ordinances, this ordinance, I think in this case, doesn't seem to ban or prohibit anything. Instead, it simply says that if you're going to use pesticides and GMOs, you need to make public notices about it. And how is that inconsistent with state law?
Well, again, with respect to pesticides, it specifically does say you may not use pesticides, or you may not even grow any plants in these buffer zones. So on that score,
Yes.
there is that. Then there are notification requirements. And again, let's keep in mind, Your Honor, that the notification requirements are incredibly draconian. The penalties here are up to 1 year in prison, plus fines of, I think, $25,000 or $50,000 a day per violation. So the county has really gone to town here. And when I answered your question before, we think there are some specific conflicts between there are conflicts at least with the ban provisions. I realize Kauai's not a ban. With respect to the notification, that's a very big deal. Let's take notification of GE plants, because we have notification of pesticides, we have notification of GE plants. On the GE plant side, there's a real concern of vandalism of the farmers who are forced to identify where in their fields they are using GE plants. There are concerns about espionage, people coming and actually digging up these seeds to get the seeds.
Okay, but all right, I understand you're stating the concerns, but does that argument on the concerns, does that go to the annual crop reporting requirement, or is that because I see that you have two separate things to analyze here. You have the pesticides component, and then you have the annual crop reporting requirement.
Yeah, and maybe just to be very clear, because
I find the pesticide argument, I'm just speaking for myself right now, that it's clearer to me that's a stronger argument than the annual crop reporting requirement. I mean,
sure.
I think because HR section 141-1 subsection 8 recognizes that local governments may research and evaluate local agricultural injuries. Doesn't this provision confirm that Ordinance's 960 crop monitoring requirement and EFIS provisions are not preempted under state law? And with this annual crop reporting, I asked over there, are we just putting a nose under the tent where you don't belong, or would it really interfere? They're just saying all you have to say is what you're growing.
Let's just try to keep the pesticides for a moment separate from the plants. On pesticides, I couldn't agree more with at least the sentiment you're expressing, that we have a comprehensive scheme. We have a whole chapter of the Hawaii revised statutes, Chapter 149A, that governs every aspect of pesticides. It governs use, labeling, distribution, and it actually, I think Your Honor, you might have made this point earlier, it has a cooperation provision that specifically uses the word uniformity. That's 149A-23, and it says, we authorize the state agencies to coordinate with the State Department of Agriculture to coordinate with other state agencies and federal agencies. There's not one word about the counties. You would think if the state, which after all is the source of authority of everything the county does, contemplated that there would be some role of the county here, the very cooperation provision in the pesticide law would say, and you can coordinate with local counties in that. That is incredibly powerful evidence that, again, we're only talking about pesticides right now, that there was no role contemplated for the counties in pesticide regulation. And one point I want to just emphasize also, it's a general point. We are all, I think, used in federal court to thinking about preemption issues with independent sovereigns on the state side and the federal government not giving them that authority. In Hawaii, it's the opposite. Every iota of authority the county has comes from the state. So the question here really is, does it make sense to think that when the state is creating this comprehensive mechanism, without any reference whatsoever to a county role in terms of either saying the county may regulate, may do X, Y, and Z, or saying that the state standards are minimum standards, that they would have wanted basically circumvention of this elaborate state scheme. So again, I think with respect to pesticides, it sounds like Your Honor at least is.
Well, don't assume anything yet.
I'm not okay. Fair enough.
Well, why don't you answer your question on the reporting requirement?
Okay, yeah. Okay, so let's now go to the GE side of the house. On the GE side of the house, there are similarly comprehensive schemes regarding allegedly or potentially harmful plants, which give the Hawaii Department of Authority incredibly broad, Department of Agriculture, incredibly broad authority to regulate allegedly harmful plants. You all might have had to fill out a form, I suspect you did, when you came into the state about whether you're bringing any plants or seeds. I'm not aware of any other state in the union that requires you to come in. This is an area, potentially harmful plants and seeds, of extreme concern to the state of Hawaii. And this is not an area that they're kind of like, well, whatever, anybody can do whatever they feel like. There's an extremely comprehensive scheme that gives authority specifically to the state agencies. And there's absolutely no contemplation of any county role in addressing harmful plants. In fact, even
if the county has some concern based on its knowledge of local needs.
You're right, and yes, and the answer is, if they have those concerns, the State Department of Agriculture is headed by a board. On the board is a representative of each of the major islands. So the county of Kauai here has a representative on the board. The fact that the county participates at the regulation at the state level is incredibly powerful evidence that there wasn't supposed to be some separate body of regulation. Another indicia of exclusivity, Your Honors, is the fact that there are boards. There's a pesticide board, and there's also a harmful plants board. Under the pesticide one is in an advisory board of experts. So it's and the pesticide one is at 149A-51, and it's 150A-10 on the harmful plants.
All right, but let's assume if you don't, okay, so if all you have to do is you report what you grow, I mean, how are local areas supposed to, maybe they have to go to the state and complain and say that this GE is coming over on, my crops and I'm growing organic and all of that they can't do that locally. But how do they ever have the information if they don't know what anyone's growing?
I think, Your Honor, the point is if they feel they need information, reporting is a form of regulation. You can exercise regulatory authority in many ways. For instance, if the feds want to regulate cigarettes, they can say, well, you must report your sales of cigarettes to minors. They can say, we ban that. To suggest that somehow reporting requirements are not regulatory, I think, is to blink reality. And I think it kind of goes to a point you made earlier that how are you supposed to use reporting as distinct from the rest of the regulatory scheme? Reporting requirements are part and parcel of a regulatory scheme. So there's absolutely nothing in the framework of Hawaii state laws that govern potentially harmful plants that suggest any reporting role for the counties. If the state wants to impose reporting requirements, God bless them, as long as it's consistent with federal law and Constitution.
They have limited resources, and so it could be, their argument would be that they need the help of the counties on certain things. The county can't do anything about it, but then if people know, then they go to these other state boards.
Well, it could be, but there's nothing in state law that actually says that or suggests that, and to the contrary. The general cooperation provisions in 141 don't talk about cooperation with the county. They talk about cooperation with other entities. Here it is. Hold on, I'm flipping to it. Encourage cooperation with Agricultural Extension Service and Agricultural Experiment Section, University of Hawaii, and private persons and organizations doing work of an experimental or educational character. There's nothing that suggests that the Department of Agriculture of the state, in any of these state statutes, should coordinate or consult, or that the counties have any power in this area. And
let me ask you this then.
Sure.
What state law, if any, does the annual crop reporting requirement interfere with?
Well, again, to the extent you're asking about interfere with, you're asking a conflict preemption question. And the state, what we are making here is a field preemption argument, that this field of...
I guess your answer is it doesn't conflict?
I think there's no conflict on the reporting requirement front. But again, that is not our argument. I think
but her
I think
question was, does it conflict?
Yes, that is correct.
You're saying, and then further, it seems like your answer to what's the harm in reporting or allowing reporting requirements by the counties is that it's, in your view, it's a regulation.
Well, it's a regulation, and I think there's very specific harms to the farmers. As I mentioned, there's vandalism harms of saying we are planting. The reporting requirement here is not some innocuous thing. It says you must identify specifically what plot of land you are putting which genetically engineered plant. And that opens the farmers up to vandalism concerns, which are very real. This is not hypothetical. This has happened. To espionage concerns. Again, this is not hypothetical. This has happened. There have been agents from other countries that have come and dug up seeds in fields. And there's draconian penalties.
Regardless of that, the state could require that.
Yes, and that's a different kettle of fish.
So these harms are sort of beside the point.
Well,
We're talking about a question of power.
I'm sorry. I thought that the point was more to say, excuse me, Your Honor.
No, I think Judge Thomas is following up correctly in that, I mean, you're giving reasons why you would argue to the state or the county not to impose regular reporting requirements, but I'm trying to figure out, you know, how does it intersect, or does it, because it seems like it more supplements than it intersects or conflicts or somehow
I think
is part of the state
supplementing,
regime.
Conflicting, that's, if you have an exclusive regulatory regime, Your Honor, we're talking now about comprehensive statutory scheme. There are rulemaking requirements. 150A-9 allows the state to pass all rules about potentially harmful plants. And these quarantine requirements are not just at the border, they're also allowing people subsequent to the entry to go after restricted plants. If the state feels that more regulation or more notification is appropriate, it's up to the state. There's a unified regime at the state level. The fact that the state doesn't have these requirements is a pretty good indication that the state doesn't feel it's appropriate. Everybody here who might want those requirements is free to go to the state and say, we should have these. And there's no question that the state has that power, except insofar as it may be preempted by federal statute or constitution. I see I'm running low on my time. Unless there's further questions, I'd like to yield to my colleague, Ms. Bronster.
Certainly.
Thank you, Your Honor.
May it please the Court, I'm Marjorie Bronster on behalf of appellees, and I'm here to just briefly discuss two matters that had come up. The first one was the question of whether or not this matter should be certified to the Supreme Court of the State of Hawaii. And Mr. Minkin argued that this should be certified to the Supreme Court because it's important. But that is not the test. The test is whether or not there is state law that is determinative of the case and whether there is no clear controlling precedent in Hawaii. And we believe that the test fails on both of those points. First, the Richardson case, which both sides have cited to you, and both sides agree is the test of preemption in the state, was a certified question in and of itself. So to take a suggestion that because you have to apply established Hawaii law to a different set of statutes, that would suggest that every case should be certified. And we believe that the court is well qualified to answer this question based on the long list of Hawaii Supreme Court precedent, with Richardson, which was certified, Citizens Utilities, Hurup, Ewing, and subsequently and recently in Ruggles, where the court went through and said, it's clear there is a state preemption test that can either be a conflict or based on the comprehensive regulatory scheme. And for that reason, Your Honors, we believe that certification would not be appropriate. It would not shorten these issues. In fact, it would result in additional delay. And there are a lot of other issues that remain. There are 10 other counts in the underlying case that would have to be addressed after this. So it would not
certainly,
be.
but I think, Richardson sets forth the test and the other cases do. The only question is whether or not they're in a better position to apply Hawaii preemption tests than we are.
Well, I think that the problem here is that the test has been established and stated.
No question.
And there's no question that it's clear. The only question is whether or not the court below got it right. And I believe that the reason that they're now asking for a certification is not because there was an abuse of discretion below, but because they didn't like the way the court came out. So we believe that the court is well equipped to answer this. And frankly, all of the courts, the lower courts in the state that have applied the preemption test have gotten it right. The courts have the Supreme Court of the state of Hawaii has routinely said, okay, here's the test, and the outcome has been affirmed in virtually every case. With respect to the public trust issues that were raised, I think that there has been a suggestion that the public trust gives the counties more rights than it does. The public trust doctrine is an obligation of the state and the counties. And in everything that the county is authorized to do, whether it is issuing permits or whether it is involved in runoff erosion control, when the county has responsibility, it is supposed to consider the public trust in meeting those responsibilities. It does not give them independent responsibilities, nor does it state where the allocation is between state and county responsibility, and we believe that the other arguments about preemption would answer those questions.
Thank you, counsel. We'll give you 3 minutes for rebuttal, and we'll give you 3 minutes as well.
Thank you, Your Honors. Counsel read to you a section about cooperation under the statute, and that was section 149A-23, and read to you that the department may cooperate or enter into agreements with any other agency of the state or any agency of the federal government for the purpose of carrying out this chapter and securing the uniformity of the rules. And made a big point about, well, the county's not mentioned. What counsel didn't read to you was section 149A-35, cooperation, which talks about the department is authorized and empowered to cooperate with and enter into agreements with any agency of the state, comma, the federal government, comma, or any other agency for the purpose of carrying out this chapter. We believe that that allows the county to do what it did. Also, what else? Notwithstanding the position that the public trust doctrine doesn't allow certain things to go on, public trust doctrine imposes on counties significant affirmative duties to protect and conserve those public trust resources, which include land, water, air, minerals, and energy sources. Kauai Springs, also Waiahole. Also, Ordinance 960 is intended to protect land, water, and air, so it supports, the public trust doctrine supports the county's role in regulating pesticides. And the duty is imposed by the Hawaii Constitution regardless of any specific statutory authority. That's what Kauai Springs says. Laws may be here. There may be delegations of powers. The Constitution, according to the Hawaii Supreme Court in Kauai Springs, basically said it passes through to you, the counties, no matter what exists at the county, state levels. You have an affirmative duty to protect the public trust. As to the issue of certification, the law was settled as to preemption with Kauai Citizens and Anamizu. But what happened? The question was certified to the Hawaii Supreme Court. Why? Because it was something that was out there that was new and novel that hadn't been discussed. There was no authority at the Hawaii appellate court level dealing with these issues. This issue dealing with pesticides and GMO'S has never been ruled upon by the Hawaii Supreme Court. It is something that needs to be ruled upon. And this issue, I realize, when we argue certification after the trial court made its determination, it's an abuse of discretion. But that power is also invested with you, Your Honors. Thank you.
Thank you very much. Put on 3 minutes.
Your Honor, everybody seems to be talking about Richardson as being the law, but the lower court here clearly ignored what Richardson had to say about field preemption, and what the appellees have done instead is simply wave their arms and say it's comprehensive, it's comprehensive, it's exclusive. It's not under Richardson. Under Richardson, the court must find a statute covering the same subject matter as the ordinance. There is no state statute here governing the subject matter of the ordinance, and I'm talking here specifically about disclosure of genetically engineered crops. There's nothing. There's not a single state law anywhere close. That the statute not only has to deal with the same subject matter, but it needs to be comprehensive, leaving no room for other regulation. There is no such comprehensive statute leaving no other room. And even if that existed, it would still have to be exclusive. The court did not find any such law. Instead, what the court did with respect to this provision was to point in the direction of a number of different laws, the quarantine law, the noxious weed law, which the court admitted did not address disclosure of genetically engineered crops. And in fact, they don't deal with disclosure of any crops. And none of them is comprehensive. None of them is exclusive. And the court said, well, but there are various sort of harmful plant laws out there. That's not what Richardson did. In Richardson, the court looked at an ordinance involving lease-to-fee condominium conversions, looked at least 6 different laws that the Richardson court said related generally to the subject matter of the ordinance, went through each one individually and said, you know what, this is close, but it is not exactly what the ordinance deals with. And it ticked them off and said, you know what, not one of these actually has the same subject matter. Therefore, none of these is comprehensive, and none of these impliedly preempts. The same result we get if we look at Hurup or we look at Stallard. The court does not define same subject matter the way this court did by saying, oh, well, it's really just potentially harmful plants. What the courts have consistently done is say that subject matter means subject matter, not some subject matter arguably conceptually similar on some level, even though the law doesn't actually cover it, which is what the court did here. With respect to the county's power and this issue of, you know, is it relevant that there is a conflict or not a conflict? It's very relevant. The police power specifically says that the county has the power to enact an ordinance on any subject it deems necessary to protect health, life, and property, unless it's inconsistent with or defeats the intent of a comprehensive state statute the legislature intended to exclusively regulate that subject matter. And in fact, if you look at the 2 cases that have actually found implied preemption in Hawaii, Anamizu and Citizens Utilities, both of them dealt with ordinances that did conflict. And when Richardson distinguished both of them, the Richardson court specifically said that these conflicted and the ordinance in Richardson did not. So there, although conflict and implied preemption are distinct doctrines, there's no question about it, they are not so independent as counsel implies. There is more of a sliding scale, and when courts, the more a court is likely to find conflict, the more it's likely to find implied preemption, and the opposite is also true.
Thank you, counsel.
Thank you.
The case just heard will be submitted for decision, and we'll proceed to argument in the case of Hawaii Papaya Industry versus County of Hawaii. And following that argument, we will take a 10-minute recess.
May it please the court, Paul Achtoff appearing on behalf of the County of Hawaii. Well, whereas in the previous case the ordinance addressed disclosure of genetically engineered crops, Hawaii County passed Ordinance 13-121 to protect local residents, the rights of farmers growing non-genetically engineered crops, the local economy, and Hawaii's unique natural environment from transgenic contamination. by freezing production of genetically engineered crops to the existing footprint while accepting papaya, which at that time was already well established and relatively widespread. So papaya was grandfathered in. Now, Hawaii has no statutory scheme within the meaning of Richardson as required by Hawaii law of implied preemption that exclusively governs either genetically engineered crops or whether or where any crops can be grown. In fact, when the county considered enacting the ordinance, it asked the Attorney General whether it was constitutional, and the Attorney General's response, which is in our excerpts of Record 36, said, "The state of Hawaii currently has no statute regulating the propagation, cultivation, raising, growing, sale, or distribution of transgenic organisms." So, in fact, 8 years ago, the County of Hawaii passed an ordinance prohibiting growing genetically engineered coffee to protect the Big Island's world-famous Kona coffee industry, as well as prohibiting growing genetically engineered taro. That has been on the books now for at least 8 years. The state never objected. The Department of Agriculture never objected. Nobody objected and said, oh, well, this is preempted by the state. You can't do this. Yet that ordinance, in effect, is virtually indistinguishable from Ordinance 13-121, and yet it's been on the books for 8 years without objection. In fact, the state has never objected. The state has never made the arguments that the appellees in this case are making and that support Judge Curran's decision. In fact, after Hurricane Iselle a few years ago went through the Big Island and blew over hundreds of albizia trees, which fell on power lines and blocked roads and trapped people in their homes without power or water, the County of Hawaii passed an ordinance allowing the county to enter private property when necessary to remove these potentially harmful plants. Did the state object? No. Did anybody object? Not that I'm aware of. And yet, under the theory, under Judge Curran's ruling in this case, and under the theory that's been argued by the appellees, the county can't do that. Yet that's exactly what the police power is for. The police power exists to allow the county to do exactly what it did with that harmful plant. Each one of these statutes, these ordinances.
And are you taking questions on federal preemption in this case? You're just talking about
my colleague will be
state preemption.
Handling those questions. So there's no question that if the state wants to regulate genetically engineered crops or albizia trees or whatever, it can do so. Nobody's denying that. That's not the question in this case, whether the state could regulate those things if the legislature decides that it's appropriate. Of course, the legislature can do that. Could the Department of Agriculture regulate them if it chooses to? Possibly. That's also not the question in this case, because mere authority to do something under Hawaii law does not meet the Richardson Court's test for implied preemption. There's absolutely nothing in Richardson that says that merely because we have a Department of Agriculture with broad authority that the county's police power has been stripped away with respect to anything that has to do with plants.
Well, but here, doesn't the law, it seems to clearly authorize the Department of Agriculture to identify and restrict harmful plants?
No question.
Agreed, okay. And it seems like the State Board of Agriculture is to set statewide agricultural policy. Do you agree with that?
To some degree, they have the power to set state policy, but I would add that statewide policy and statewide, even a law of statewide application is not the same as exclusive authority that precludes exercise of the police power.
So I guess that's where I'm headed, and where you're at, I guess, because I'm just trying to figure out why would that power not be exclusive?
Well, I think the burden on someone on a party alleging preemption is to prove the exclusivity. The question is, where is that exclusivity? Is it in the legislative history? Is it in the language of the statute? All we have is a statute that says the Department of Agriculture, if it wants to, pardon me, may designate a plant as restricted. Well, fine, let it do that. And if it does that, if it wants to designate a genetically engineered plant as restricted, I don't see anybody complaining. If it wants to designate an albizia tree as restricted, great. Then the counties won't have to do it.
And you agree that there's no part of Hawaiian law that specifically gives the counties authority to identify and restrict harmful plants?
I believe that it's clear under Hawaii Supreme Court precedent that the police power is all the power that the county needs.
But my question was specifically, so just...
Well, a specific law that specifically delegates...
or just gives the county authority to identify and restrict harmful plants.
I'm not aware of any such law. But as I was saying, that it's established that the Hurup court specifically said, well, you have the police power. That's all you need in the absence of preemption. So you do not need a specific delegation on everything that is covered by the police power. The police power is broad, and that's the language of the Hawaii courts.
So how do you, with respect to implied state preemption, how do you distinguish in application of Anamizu, which concluded that a city ordinance regulating contractors was preempted by state statutory scheme that vested a board with broad powers relative to the licensing and regulating of contractors? So, is it your position that a broad delegation of rulemaking authority to a state agency can never preempt local laws concerning subjects that fall within the scope of the delegation unless the agency has issued a rule regulating that specific subject?
I think my position would be close to that, but let me deal with your question about distinguishing Anamizu. In Anamizu, the state created a specific licensing scheme requiring all contractors to get licensed by the Hawaii Contractors Licensing Board. And this license affirmatively granted contractors the right to practice their trade throughout the state. And then the county ordinance specifically prohibited duly licensed contractors from practicing in that county without an additional credential, and in the words of the Anamizu court, quote, severely diluting the value of a uniform state licensing system. And the conflict was clear, and the court emphasized it. The court said a person satisfying the state standards acquires permission to pursue his occupation throughout the state. And this permission may not be circumscribed by local authorities. And that was key. There is no state law addressing the ordinance's subject matter. No state law grants anyone the right to grow these crops. And there is no interference with any state law. So the Anamizu is distinguishable in all of those ways, which are some of the ways in which Richardson distinguished Anamizu.
But here, if the State Department of Agriculture is authorized to regulate harmful plants and has chosen not to ban the GMO'S.
We don't know that.
Well, I'm just proposing this. Let's say they're authorized to regulate harmful plants and then has chosen not to do that or chooses not to do that. Just on that premise, isn't the county ordinance prohibiting what the state law permits?
State law does not. If the state had a law that said you may do this, then I would agree that the county cannot pass an ordinance that says, no, you may not. That's anamizu. The county has no law saying you may grow whatever you want wherever you want. All that we have is a Department of Agriculture, which, like every Department of Agriculture in the country, has broad authority to deal with harmful plants. That does not cut off the county's police power.
But wouldn't that be a conflict?
I see no conflict. There is no right that anybody is treading on. There is no state action that is being conflicted with. All we have is a department with broad authority, which it can exercise in various ways and has not exercised in this area. And if it wants to exercise it, then we would look at how it exercised it in relation to the ordinance.
Thank you, Counsel.
Thank you.
Gabby, why don't you put on 7:30 for... We'll give you your 7:30. Your request.
Thank you, Your Honor. Good morning. May it please the Court. I'm Andrew Kimbrell. I'm here on behalf of Hawaii County. I'm here to discuss the federal preemption issue.
Morning.
The sole issue before the Court in this appeal is whether the preemption clause under the Plant Protection Act actually covers the Hawaii County ordinance. In the court below, the industry did say that there was perhaps an implied preemption claim that was rejected by the court below, and subsequently the industry dropped its appeal. So here we are with the clause itself. And I want to just discuss briefly the very unusual legal setting in which we examine this particular question. In 2013, this court in Center for Safety versus Vilsack held that the very harms that the county is trying to avoid, which is transgenic contamination and pesticides use accompanying that those transgenic crops, were not plant pest harms under the Plant Protection Act. The court specifically held, yes, there are real harms. Yes, there's economic harms. Yes, there's transgenic harms, but they're outside the scope of the Plant Protection Act. The agency's hands are tied. They can't do anything. At the same time, in the USDA's briefing, APHIS came before this court and said, we agree. Our hands are tied. We cannot do anything about transgenic contamination. We can't do anything about the pesticides that go along with these transgenic crops. But, and they specifically said, this should be handled in their briefs, and it's in our brief, this should be handled through state and local planting restrictions. This is in 2013. So here we have this court saying, hey, the matter of this ordinance is not something that's under the scope of the Plant Protection Act. Sorry. And then we actually have the relevant agency that you think that they would know whether it's preempted or not. It's their agency. It's their preemption clause that they regulate. And they said, no, actually, this should be solved. The answer here is no fears. These real harms of transgenic harm, these real harms of pesticides, they are going to be solved at the local and state level through planting restrictions. So it would seem to me fairly implausible at this point that the court would say, listen, this statute doesn't have the power to regulate the harms that are in this ordinance. But it does have the power to restrict the states and localities from doing that, even though the very agency involved says, yeah, that's exactly the way to handle it, state and county planting. And it reminds me a little of the Lohr case, where if that were to be true, then these real harms, and not only this court, but even the Supreme Court in MONSANTO versus Gertz and Seed said these are real harms, harms so significant that the farmers there had standing in that case, there would be no redress. As that court said, it is hard to believe that Congress intended to give no redress to a group of people who are suffering harm.
Can we drill down on the federal preemption since we have limited time here? Now, with respect to the express federal preemption issue, do you agree that the county ordinance seeks to control plants that are regulated by APHIS as plant pests under the PPA?
No, we do not agree. There are several categories of plants that are covered, and the definitions are different. The articles we're talking about here that are pursuant to the ordinance, the ordinance is regulating, are regulated articles. They are not plant pests. They are not noxious weeds. No genetically engineered plant has ever been determined by the Secretary to be a plant pest or to be a noxious weed. It's never happened, not one. 117 regulated articles have gone through this process, which this court has described quite accurately as a presumptive plant pest, goes through the process to see if it is, and I'm quoting this court exactly, an actual
What
plant
about
pest.
presumptive plant pests are regulated by APHIS, like other plant pests, aren't they?
Presumptive plant pests are regulated by APHIS, yes.
So why shouldn't they be considered plant pests for the purposes of the express preemption analysis?
Well, we have right now 2 presumptive candidates from each party for presidency. They are not actual candidates, they are presumptive candidates. We have reason to believe they may be candidates, but they haven't gone through the process yet. A regulated article is not a per se plant pest.
APHIS? No, not yet.
Not yet. They may not be regulated sufficiently either, Your Honor. Let's move past that.
So let me ask.
The regulated article is not a per se plant pest, and that's why I said it's very important, the language in Center for Safety versus Vilsack, because there, Judge Schroeder says, listen, the whole point of the examination is, does this presumptive plant pest then become an actual plant pest through this long review process in Part 340? That's the whole process. If it were an actual plant pest to begin with, which is what the industry is saying, then that would be a different process. They would say, here, we have a GMO, it is a plant pest, and now we're looking to see if it stays a plant pest. That's not what the court says. That's not what the Supreme Court says, and that's not what the regulations say. They say...
Right, I'm just trying to... So
Sure.
if a presumptive plant pest were not a plant pest within the meaning of the Plant Protection Act, wouldn't it follow that APHIS lacks authority to regulate presumptive plant pests?
No, it wouldn't, because under the preemption clause, right, the reason this is important, the reason we're talking about it in terms of preemption, is that the preemption clause says this only applies if the county state ordinance is done in order to control a plant pest or a noxious weed, right? In order to control, right? So if it's not, as in the case of Hawaii, it is not there, this ordinance does not control a plant pest or a noxious weed, but rather a regulated article, it does not fall afoul of the preemption clause.
Well, let me give you a hypothetical then. If the panel were to hold that, this is a hypothetical, that only express federal preemption applies, would the ordinance be facially invalid or only invalid as applied to plants that are regulated under the PPA and have not been deregulated?
We agree with Judge Curran's lower court ruling that to the extent that a regulated article has been determined to be a plant pest or has been determined to be a noxious weed, it would be preempted if it also fulfilled the other prongs, and there's other prongs of this preemption clause. Because it says you have to be, in order to be, for this to apply to you, county ordinance, state ordinance, you have to be regulating a plant pest or a noxious weed. If that were to be determined, it hasn't been determined yet, no GE crop, no regulated article ever has been, but should they do that, we agree with Judge Curran's decision. We hope you'll affirm that decision saying yes. To the extent that a regulated article is then determined to be a plant pest or determined to be a noxious weed through a separate administrative determination, yes, then it would fall afoul of the preemption clause and it would be preempted.
So just to be clear, you're saying that the ordinance does not restrict GMOs that are also plant pests?
I see my time is up, Bill.
Go ahead and answer.
I'm sorry, could you say the question again?
Go ahead and answer.
So you're saying that the ordinance does not restrict GMOs that are also plant pests?
That's correct. It does not, at this point, do that, no. And it could not do so. Should the agency at some point make a separate determination that one of these regulated, one of these presumptive plant pests is an actual plant pest, yes, then it would fall afoul, as Judge Curran said in his decision. We agree with that. We have no disagreement with that.
Thank you, counsel. And to equalize the time, why don't you put 20 minutes on? Yeah.
Thank you, Your Honor. May it please the Court. I'm Chris Landau, and once again, I'm here to address the state preemption issues in this case. With me today at council table is Rick Bress, who will address the federal preemption issues in this case. I'd like to start, if I might, just with the legal framework that we have here, which is the Richardson test, because I think it has been even though the test is very clear, I think opposing counsel has really muddied the waters there. That test said that a state law, whether a state law preempts a county ordinance, depends on whether it covers the same subject matter embraced within a comprehensive state statutory scheme, disclosing an express or implied intent to be exclusive and uniform throughout the state. I think a lot of the discussion that we've heard this morning is along the lines of saying, well, nothing in the state laws regulating potentially harmful plants prohibits the counties from doing anything in this area. But we know from Richardson on its face that this intent can be implied, as it was in the Anamizu and Citizens Utilities case. And those were very much cases where the Hawaii Supreme Court looked to comprehensive state authority that was given over a particular area and said, when we're dealing with counties, which after all are creatures of the state and are authorized to exercise only those powers given by the state, we have to figure out what was the state really intending. If the state created a comprehensive scheme, was it really leaving room for the counties to supplement? Or was it meant to be exclusive and uniform at the state level? With respect to GMOs, the county now wants to pass a complete ban. In this case, we're talking about a complete ban on GMOs on the theory that they are allegedly harmful plants to other plants and to the environment because of these cross-pollination concerns. Those are the very kinds of concerns that the state can regulate through its comprehensive mechanism under the quarantine laws, section 150A, which is an entire subsection of the Hawaii Code, which I'm sure we all had to fill out those forms on the plane, which go to that very issue, that they're very concerned about bringing potentially harmful plants into the state.
Well, but let me ask you this.
Okay.
How can we hold that a state law impliedly preempts counties from banning GE crops when state law, including HRS sections 141 to 143 and 194-2A, clearly recognize that counties may control plant pests? And then you've got the state Attorney General's letter explaining that the state does not have any laws regulating GE crops. Isn't that persuasive evidence that the legislature did not intend exclusive state regulations of GE crops?
Absolutely not, Your Honor. Let me start with that letter, because I think the opposing counsel made a reference to that, and that is incredibly misleading. That letter was a...
Well, kind of, yeah, so unmislead me then.
Please. That letter was a response. It was an email response to a letter sent one day earlier by the county of Hawaii saying, we've seen that we're considering a bill. It was a different bill at that time. It was more about labeling. And it says, we've seen that you recently, Attorney General's office at the state level, had expressed some constitutional concerns about that. Those were all about labeling. They were First Amendment concerns. It's attached. We attached this to our brief, and the letter that the county was referring to, the state letter, is also attached there. It is clear that the county was not asking about is the state scheme exclusive. And in the state letter responding to that, it says Hawaii has no statute regulating GMOs or GEs as such. Well, we don't dispute that there's no there's no statute specifically regulating GEs. It falls within the ambit of all the various plants that regulate a broader field, potentially harmful plants. We don't agree, by the way, that these would fit within the regime of potentially harmful plants because we don't think they're harmful. The point is, they believe that the county's concerns, the very concerns that underlie the ordinance at issue here, are concerns, as we heard today, about cross-pollination. Okay? Those kind of concerns are precisely the kind of concerns that the state has complete and a very comprehensive regulatory system over. The 150A system, the 152 noxious weed statute. There's an advisory board on potentially harmful plants. There is an incredibly reticulated scheme. And they say, oh, well, you can't have a comprehensive state statutory scheme when you're talking about multiple statutes. That gets things backwards. The fact that it's being addressed in multiple interlocking statutes only underscores how deeply the state is involved in covering this. The idea that the state is leaving the county's room to completely ban a category of plants that the state has said it's fine to bring them in is preposterous. I mean, this is not an area that the state doesn't care about or doesn't have a mechanism. There is this reticulated board that covers when it comes in. Those are the quarantine laws, which even allow the state to go beyond the quarantine, go into the fields and after the point of entry to make sure those are enforced and allows restricted plants. Then there's the noxious weed statute. They say, oh, this can't be a noxious weed. They cite an Oxford English dictionary for the proposition that a weed is something that's unintended. But the Hawaii definition of noxious weed in the state statute is much, broader. It says, any plant species which is or may be likely to become injurious, harmful, or deleterious to the agricultural industry of the state, as determined and designated by the department from time to time. Again, we believe that it's not deleterious and shouldn't be classified as that, but they believe that it is. This is the debate that we should be having at the statewide level. There's no room here to have this debate at the county level and have the county be banning things that the state has allowed in and the state has determined do not meet these responsibilities, these requirements.
Is there anything in Judge Curran's opinion that you disagree with?
On state preemption, Your Honor, I would say no. I think he very clearly explained that there are these comprehensive regimes. I can't speak to the federal preemption issues.
He finds federal express and not federal.
And Mr. Bress will speak to that. I'm the state guy here this morning for this case. But I wanted to go back to the point. We've heard a lot from the other side about, well, there's this police power statute in Hawaii. That is a very general police power statute, but it actually is very carefully limited. It's general, not specific, doesn't say anything about plants. And then it says, you may have this police power on any subject matter not inconsistent with or tending to defeat the intent of any state statute where the statute does not disclose an express or implied intent that the statute shall be exclusive and uniform throughout the state. So the state very carefully, in the very provision where it was giving this police power, said, but wait a second, we don't want anybody to construe this as a blank check we're giving the counties. We're only giving it, but pursuant to, you can't have authority that goes beyond or that would trench on an area that is expressly or impliedly occupied by the state. And I think it's interesting, the Hawaii Supreme Court in Richardson took as its preemption test basically this language. So the preemption is kind of the flip side of the authority issue here. The police power is circumscribed to prevent it from encompassing things that would otherwise be preempted, that are being dealt with at the state level. So I think that's really
I know you're arguing that the state, the Department of Agriculture has comprehensive authority over this, or that as a result of the broad authority the Department of Agriculture has.
Right.
The state has a sort of comprehensive regulations in place, but I guess I'm just trying to figure out how do we know, and I'd like to see what you say to this. How do we know that the Hawaii legislature didn't intend for the state Department of Agriculture's plant regulations to set like the minimum or the floor for their policy, such that the county could supplement with their own regulations? Because probably a state can't anticipate everything.
Sure.
And so what's your response to that?
My response to that is the Hurip case, which has been cited by the other side, which is a case where the state statute made it clear, and it was the statute in the legislative history, that it was intended to be a minimum floor. And that's a case where a comprehensive statute was about insurance, car insurance, and the state statutory scheme, the same argument was made. Hey, there's a whole comprehensive state scheme for insurance that preempts the county ordinance. The court looked at that scheme and said, well, we're looking at the legislative history, and there are references here to this is a uniform minimum basic standard of insurance. And the fact that it was minimum suggested that it did not occupy the field for that reason. There is absolutely nothing in the legislative history or the statute here that suggests that the state regulatory authority for harmful plants is just setting minimum standards. And I can't overstate the importance of this. In all of the cases in which the Hawaii Supreme Court has...
There's nothing saying that it's not.
Well, Your Honor, but that's why you have to go back And then you're kind of in the land of looking for indicia that makes it comprehensive. And I think here we're not just relying on the comprehensive scheme. We're also relying on the fact that state officials are brought into the scheme. There are representatives of each of those, county officials are brought into the state scheme to make sure that they participate, have a voice there. Again, that is inconsistent with the idea that the counties had independent regulatory authority. We're relying on the fact that in both pesticides and harmful plants, I guess this is a harmful plant, this is the harmful plant case, 150A-10 creates an advisory committee on plants and animals, again, that doesn't talk about the counties being involved. To the contrary, it talks about expertise. Certain experts in the area have to be there. The state regime is a uniform regime based on scientific expertise. There's no contemplation that counties based on political concerns or whatever, voter initiatives can come in and say, well, we think this is what we want to do. I mean, the state regime, to the extent it's based on expertise, is inconsistent with that.
And what case do you point to that you think serves the best example for us to follow that's most similar to your situation?
I think the Anamisu case, for the very reasons that Judge Callahan described earlier, the court said that there's a very comprehensive state regime. It allows the contractors to practice their trade and by implication, it doesn't allow the counties to supplement that. The exact thing could be said here. There's a comprehensive regime that allows these GE plants to be brought in and used in Hawaii without being restricted or regulated, therefore the counties impliedly can't go and do what the state didn't do. That would be inconsistent with that reticulated statutory scheme. So I think those provisions, when you look at them, there's a fundamental legal issue here that I think is important for the court to understand. The other side makes the argument that unless, and to the extent that the state doesn't actually exercise a particular regulatory authority, the extent of the regulatory authority per se is irrelevant. We're only looking at things the state has done. They base that on the Ewing case from the Intermediate Court of Appeals. The Ewing case is very different because in the Ewing case, there was a state law that said, it was a noise ordinance, and this is about a boombox, and somebody was prosecuted under the local ordinance about noise. And one of the defenses was noise is exclusively a statewide issue. And the court said, no, it isn't. We're looking at the state statute, and the state statute says the counties may regulate noise except as inconsistent with a state rule. So they said, well, there's no field preemption here because we see on the face of it that it is allowing the counties to have a role except as inconsistent. So it's obvious that in Ewing, they were looking to see whether there was an inconsistent state rule. And they decided that the state rule there was not inconsistent because it governed vehicular noise, and they decided that means noise emitted by the vehicles, not by a boombox inside the vehicle. But that case certainly does not stand for the proposition, as they are suggesting, that to have a comprehensive statutory or comprehensive state scheme preemption, you have to actually identify affirmative regulatory authority. And I think the key point here is that the Hawaii framework of statutes contemplate no role for the counties in banning or otherwise regulating GE crops. And to allow county bans would turn that absolutely on its head. Again, understanding and keeping in mind that the counties have no authority except insofar as it comes from the state.
Your time is winding down. We better get to federal preemption.
Thank you, sir. Thank you, Your Honor.
Judge Thomas, and may it please the court. I'd like to first correct some of the framing of the express preemption provision and then address its specifics. In terms of the framing, APHIS didn't say in Vilsack, and has never said, that it lacks the ability, for example, to protect against cross-pollination for crops that it is still regulating under permits or under notification. To the extent that it was discussing its lack of authority in that respect, it was talking about crops that have been deregulated. Crops that are under regulation are actually regulated quite stringently to protect against cross-pollination and the like. That's in...
I guess they have talked about that, but the record and previous court decisions show that genetic drift from GE crops have caused significant economic damage to non-GE farmers. And so isn't managing this type of land use compatibility issue with the traditional core power of local governments?
Your Honor, it may be within their power, but for the fact that the federal regime is regulating it, and the state's interference with that, or the county's, in this case, interference with that, would actually disrupt and frustrate the regime. And the reason, I'll get to this a bit more in implied preemption when I discuss this in the next case, or the case after that. But the rationale, essentially, is that these field trials are going on for two purposes. Number one, because the agency has the authority from Congress under 7701 to facilitate commerce in plants, and while at the same time protecting against plant pest harms. So they're allowing the field trials both to accomplish that goal of facilitating commerce in these plants, which were found again under that same section to be critical to the U.S. economy, but also because the agency has to determine whether these plants rightly are within its jurisdiction. In other words, whether these really are plant pests. And an inability to have these kinds of field tests would deprive the agency of its ability to actually determine its own jurisdiction, because without the field tests, the agency doesn't have the data to determine whether these should be deregulated or should continue to be regulated as plant pests.
Well, I know you're gonna argue both of them, but I mean, there's a couple things I want to ask you. Do you agree that express preemption clause does not apply to state and local regulations of federally deregulated GE plants?
Absolutely, Your Honor.
Okay, so that's not really at issue.
That's
here.
not at issue in this.
Okay, but then I'm assuming that, I don't know if you're probably going to cover it, you're going to cross-pollinate here between this and the next case. I think that
as long as this court doesn't regulate against that.
Yeah. Judge Curran found express a preemption, correct, and not implied.
That's correct.
And Judge Mulway in the other one found both, right?
That's also correct.
All right. So, and when I was asking Mr. Landau about was there anything he disagreed about Judge Curran, I'm assuming you're going to say that you think he got the implied preemption wrong?
That's exactly right, Your Honor. I think he got things half right.
Okay.
I prefer to think
But
positively.
you're not raising that as a cross.
We have not, Your Honor.
Okay, so we'll talk about that
We'll
over
talk
on the
about
other
that.
one? Okay.
In terms of the express preemption, then, the agency has prior to the enactment even of this statute, the agency had long taken the position, and we've cited in our briefs, and for example, you can find it at 58 Federal Register 17053. It's always taken the position that to the extent that it is regulating a crop, to the extent that it has regulatory authority of the crop, the states can't add additional requirements during that time period. The express preemption provision at issue in this case is an outgrowth of that historic position that APHIS had always taken. And the ordinance here flunks all three requirements, or one could put it differently, meets all three requirements of the express preemption statute. To begin with, these are crops, as Your Honor mentioned, that are regulated by APHIS as plant pests. APHIS told the court this in Vilsack on page 5 of its brief. This court recognized that. To the argument that these are merely presumptive plant pests, actually there's a definitive answer to that as well, which is when this regulatory scheme under Part 340 was first enacted, APHIS explained in the preamble to its notice of proposed rulemaking exactly what it was doing and why. And what it said, and this is at 51 Federal Register 23355, it said USDA is proposing to regulate only genetically engineered organisms or products which are plant pests or for which there is reason to believe are plant pests. It then went on. USDA believes that an organism or product is a plant pest, is one, if the donor, recipient, vector, or vector agent of the genetically engineered organism or product comes from a member of one of the groups listed in Section 340.2. That's all of the plants that are at issue in this case. They all have plant pest constituents. It then went on and said, USDA further believes that a genetically engineered organism or product should be designated as a regulated article when, based on experience, the deputy administrator determines the organism or product is a plant pest or has reason to believe is a plant pest. So the first category, which he said the agency believes is a plant pest, are the ones that are at issue here. There is another category of regulated articles where, for other reasons, APHIS might determine they are plant pests or have reason to believe. But the category here is being regulated as a plant pest based on APHIS's determination that that's how it should be regulated until or unless it is proved to the agency that it is not a plant pest, at which point it's deregulated. But until and unless that happens, it's regulated as a plant pest. So that's one of the three requirements. A second requirement is that the ordinance that's at issue here, the Big Island Ordinance, is regulating because in order to prevent the dissemination or introduction of the plant pest. That's undoubtedly true here. The entire ordinance's point is to prevent the dissemination and introduction of these plant pests. Now they say otherwise because they say, well, the reason we're doing that is different. We're doing that in order to protect against pesticide harms, or we're doing that in order to protect against cross-pollination. This preemption provision isn't interested in that second level reason. So long as it's in order to prevent the dissemination or introduction of these plants, and it undoubtedly is, it doesn't matter what reason they've got for it.
So I mean, ask you in a different way. So what's your position on whether the ordinance bans GMOs that are not plant pests? Does it?
Your Honor, okay, I think I understand your question.
Because
it may on its face, and let me address this if I may, just for a second, and if I'm not answering you, I'm happy to pause. But it does on its face appear to regulate plant pests that are not made with a plant pest constituent as well.
Right.
And those are not regulated as plant pests, and we're not arguing that it is preempted to the extent it touches those. But as we noted in our brief, to our knowledge, there aren't any in Hawaii anyways. So in terms of the relevant plant pests that we're talking about here, they're all made with in terms of the relevant GE crops that are at issue here, they are all made with a plant pest constituent and therefore are regulated by the agency as plant pests, and the ordinance does cover those. Does that answer your question? I'm sorry.
I think it does, because I'm just trying to figure out if the ordinance could expressly preempt GMOs that are plant pests, but yet not expressly preempt those GMOs that are not plant pests. Does that make sense?
I think that it's in fact what it does do. I don't think it's speaking to non-plant pests. I think that...
And you would agree then it doesn't expressly preempt non-plant pests?
That's right. To the extent that you've got a not plant pest, this provision isn't speaking to it. That's correct.
And I gather your position is if the state of Hawaii adopted the language that was identical to this ordinance, that would be preempted.
Same result, Your Honor. The federal scheme doesn't distinguish between the states and the counties in that regard. The third requirement...
So how does federal preemption work in your view, given the state scheme? Does the federal express preemption affect the current state scheme in your...
No, Your Honor, because the state, to this point at least, has not chosen to try to regulate GE plants. It hasn't singled them out for any kind of regulation. It hasn't singled them out for reporting, for bans, for anything of that sort. So there's nothing to preempt right now in the state scheme. If the state, I agree that the state has authority qua state within its state scheme to attempt to do that kind of a regulation. If it did so, we would think it would be preempted just the same. The third requirement of the conflict preemption statute, of course, is that the ordinance is regulating the movement in interstate commerce of the plant at issue. And on that, again, we think that Judge Kern got it right. The reason is two. First of all, you've got plain language here, which is the word movement is defined under the Plant Protection Act to include release into the environment. And while it's a bit of an odd phrase, release into the environment in interstate commerce certainly takes in the kinds of things that this ordinance is trying to regulate. Because they're trying to regulate, for example, if through pollen or through seeds being stuck in tractors or what have you, these GE crops are being grown in a field that is a conventional or organic field and therefore entering commerce in that way, and they're trying to protect against what they view as those harms.
Of course, it makes sense if you're in California and you're talking about Nevada, but in Hawaii it's a little bit different.
It's a little bit different, but again, Your Honor, when you're talking about a plant that can grow in a neighboring field, absent, again, strong regulation by APHIS, and by the way, the regulation really is quite strong and quite rigorous. If it enters that next door neighbor's farm and it grows, the plants that are being sold from Hawaii by no means are being limited to sale within Hawaii. They are sold interstate, and there's no question about that, entering interstate commerce. But there's another reason as well, and this has to do with history, because understanding this term is made a whole lot easier by understanding where it comes from. And that's that when 340 was first promulgated, in the preamble, APHIS addressed some comments that had come in that said, well, we don't understand how you can regulate mere releases into the environment, because it seems from the statute you're only allowed to regulate imports, exports, and the like. And APHIS took the position that the statute was broad enough to allow it to regulate releases into the environment, even though that wasn't expressly defined within the term movement. When Congress amended and consolidated the statutes into the Plant Protection Act, Congress added release into the environment into the definition of movement. There's no way to read that other than to shore up APHIS's ability to regulate under the regulation of movement in interstate commerce prong, regulation of intrastate planting that causes these sorts of releases into, or could cause these releases into the environment. The argument otherwise actually would strip APHIS of its entire authority to regulate intrastate planting, because under 7712, the same phrase is used, and under 7711, the same phrase is used, movement in interstate commerce, to define what the agency's permitting authority is. And so if you took my opponent's argument to heart, APHIS would lack the authority to regulate intrastate planting of GE crops. Now, that's not a tenable interpretation because when Congress enacted the Plant Protection Act, it expressly incorporated the regulatory scheme that had pre-existed and said that that would continue to be effective until changed or until or unless changed by Congress. The idea that Congress the idea that Congress in a statute like the Plant Protection Act, which was explicitly meant to enhance the authority of APHIS, took away all of APHIS's authority to conduct these field tests and have intrastate planting restrictions is really kind of beyond belief. I don't even think my opponents are really arguing that, but that is the consequence of adopting their interpretation of movement in interstate commerce.
Thank you, counsel.
Thank you.
Three minutes.
The issue here with respect to the state implied preemption is that, as Judge Curran said in one of his orders, and perhaps in both, but they're equally applicable, he said these plant-related laws that the state has, quote, set out the state's role in identifying potentially harmful plants, and that they do. But Judge Curran wrongly concluded that because the state has a role, the counties do not. And that's the crux of this. Mr. Landau said that these are the kinds of concerns the state can regulate. Fine, we agree. But because the state can regulate does not mean that the county cannot. There are mention of various statutes that are sort of kind of pointed to as potentially regulating, but if the quarantine statute, for example, is the law that Richardson requires that the court find exclusively governs genetically engineered crops, why didn't Judge Curran just say so? He didn't. And if it's the exclusive law governing genetically engineered crops, where does that leave the noxious weed law? Clearly, neither of them is exclusive, which is what Richardson requires. Does the noxious weed law even cover genetically engineered crops? Well, we've explained in detail in our brief why the existing regulation of the Department of Agriculture would preclude designating a genetically engineered crop as a noxious weed. It must be, for example, it must be capable of competing with cultivated crops for nutrients, water, or sunlight. Well, these are cultivated crops. They don't compete with cultivated crops. They are the crops that the noxious weed law was designed to protect. They're simply not noxious weeds within the meaning of the noxious weed law. Could the Department of Agriculture enact a regulation that makes them noxious weeds? Perhaps it could. It hasn't. And with respect to the quarantine statute, this ordinance does not regulate the import or export of genetically engineered plants. They're free to pass in and out of the state and in and out of the county. They do it every day. All this regulates is growing them within the county. And the quarantine law there's plenty of legislative history, which we've cited in our brief, which makes it clear that it's about importation. It is not designed to regulate what you can grow. So where is the Hawaii case from the Hawaii Supreme Court that in any way supports the analysis that Judge Curran did? There simply isn't one. It doesn't comply with Richardson. Europe doesn't support it. I've already distinguished Anamizu. There's the only other case out there that anybody cites is the Citizens Utilities case, but that is a case in which the state granted the Public Utilities Commission exclusive authority over a very specific, well-defined field, all public utilities. There is no analog here with the Department of Agriculture having exclusive, well-defined authority over genetically engineered crops or any relevant subject matter. And in Citizen Utilities, the county enacted an ordinance which clearly and directly conflicted with what the PUC had done, making it impossible to comply with both, which is something that the court pointed out as significant. So there is no case in Hawaii that supports Judge Curran's implied preemption analysis. And the only other thing I want to say before I sit down is I just heard counsel...
Did you mean to say his implied or his express preemption?
Implied. I'm sorry if I said otherwise, but I meant implied.
No, okay.
I'm talking only here about the state preemption of the ordinance.
Oh, okay, the state.
Yes.
Okay.
The last thing I want to point out is that I want to agree with something that I heard Mr. Briss just say, which is that the state has no scheme regulating genetically engineered plants. We agree with that, and we believe that because it does not, there is no scheme to be preempting this ordinance.
Thank you, counsel.
Just a few things. Your Honor, first of all, the assertion that APHIS USDA actually has the power to regulate cross-pollination, which the opposing counsel said is simply false. I point you to page 28 of our reply brief, and the APHIS, and I'm quoting APHIS, APHIS reasonably determined that cross-pollination is not a plant pest risk. Gene transfer does not itself injure, cause damage, or cause disease in any plant. In that way, is not part of the plant pest. This is for, they have no regulation over deregulated crops. So this is about these field trial crops. So, and this was affirmed, of course, in the San Francisco versus Vilsack. So that is not correct that the USDA has any regulatory power over cross-pollination. It doesn't, and this court affirmed that. Second thing I'd like to deal with is it is true that the first trigger in the preemption clause is that the ordinance in question has to involve a regulation of an article in movement in interstate commerce. Now, we can't separate movement, which opposing counsel tried to do. We agree that releasing the environment is kind of a movement. It releases something into the environment. But you cannot release that from the prepositional phrase in interstate commerce. Commerce is defined in the regulations as trade, traffic, or other commerce. The very definition of a regulated crop, which is what it issues here, these field trial crops, is that they cannot be in commerce until they've been deregulated. This is confirmed by the Supreme Court in Monsanto versus Gertz and Siege. You can't regulate. So they are not, by definition, they're not in commerce. And since it's intra-county, they're not interstate anything. They're not interstate activity. The first state's 3,000 miles away. And this is not even interstate. This is intra-county. So the idea that somehow this ordinance involves, which it has to, this is the original trigger of the preemption clause, somehow has to involve an article that is in interstate commerce when these items are lawfully not in commerce. When they're not interstate, they're intra-county, right? So I think that you cannot, I mean, friends have neighbors. Words have neighbors, and you cannot somehow separate movement from the prepositional clause in interstate commerce, and there's no doubt that these articles under the ordinance are not in interstate commerce. And the final thing I'd like to talk about, and it's really important, is the definition of regulated article, which is in the definitions, 340.1. Opposing counsel said somehow the definition of regulated article means that every regulated article is per se a plant pest, and therefore, in the second prong of the preemption clause, which says you're only preempted if you're dealing with a plant pest or noxious weed, and they say, well, it's dealing with plant pests because every regulated article is a plant pest, or at least these ones that we're talking about. But that's not true. If you look at the definition, it is very clear that there are two categories. At the end, it's very clear. And these are the two categories. The only two categories of a regulated article are those which the administrator determines is a plant pest or has reason to believe is a plant pest. Or has reason to believe. Two categories. So that's your choice, regulated article. In every case, because the bacterium involved in these plants has been disarmed and put into these genetically engineered corn plants and other plants, the agency says, does the mere presence of that now genetically engineered disarmed bacteria that used to be a plant pest, is it going to exhibit any of those harms in the genome that is in this plant? And they take a look at that, right? And they say, 117 times out of 117 times they said no, because they had reason to believe it might. So far, if you look at those two categories of regulated articles, on one side that have been determined by the administrator to be a plant pest, 0. On the other hand, that might be, presumptively, may believe, is the second category here, to be a plant pest, 117. So the fact that somehow this definition automatically makes a regulated article, these field trial crops that we're talking about here, a plant pest, is simply false. And it seems to me that there's been a lot about plain language being the intent of Congress here. And it seems to me what the other side would actually like to do here is they would like to add to the series of things that are covered, not just plant pests or noxious weeds, but also say, you know what, this got to include regulated articles. They could have done it, right? The statute actually was done after the regulations, right? Subsequent to the regulations. They saw the regulations. They chose not to put regulated articles in there, but only plant pest and noxious weeds. And they would also like to amputate the term in interstate commerce from that and just say, hey, this applies to any plant that's in movement. That kind of linguistic surgery is not something that this court can do. That's something they should go to Congress to see. Thank you very much.
Thank you, counsel. Thank you all for your arguments this morning, and we will take a 10-minute recess.
Thank you.
All rise. This court now resumes its session.
May be seated. We'll now proceed to the oral argument on the next case on our calendar, which is Robert Ito Farm versus County of Maui.
Good morning. May it please the court. Summer Odo of Earth Justice, appearing on behalf of the Moms on a Mission Hui, Moloka'i Mahi'ai, Jerry Ross, and Center for Food Safety. My clients represent mothers, organic farmers, and beekeepers who suffer from health and economic harms caused by the appellee's GE and pesticide operations in Maui County, significantly on the island of Moloka'i. And my clients are here before you today because the courthouse doors were shut twice on them unjustly. First, when the magistrate judge misapplied the intervention rule and second, when the district judge refused jurisdiction. But before I get to the issues of jurisdiction and intervention, I think it's important to summarize briefly what transpired below, how we got here. A year and a half ago, we filed a timely motion to intervene in the Maui lawsuit, just 8 days after the complaint was filed. And by that time, the appellees and the defendant county had contacted the court to say that it would consent to magistrate jurisdiction. And this was the very same magistrate who just less than 3 months earlier invalidated the Kauai ordinance in Syngenta Seeds. At that time, the county was the only existing party defendant, and the county openly opposed the GE initiative. It would not enforce the initiative. So the magistrate judge, in ruling on our motion, correctly found that the county would not adequately represent my client's interests. But then the magistrate judge threw us a curveball. He subjected us to a burden of proof that we did not have under Rule 24A2. In the very same order, the magistrate granted the co-applicants Shaka intervention, then called Shaka existing parties, and then compared our interests to Shaka's to deny our motion, and all without giving us an opportunity to brief and to be heard on that issue. And
Well, a judge doesn't have to let everyone in the world that wants to intervene. I mean, by looking at this courtroom, there might be a lot of people that would like to intervene. So a judge can control the number of people. When you're not a party, how many people, that you can consolidate people that can represent your interests. You're not disputing that, are you? Or do you think anyone that wants to gets to?
Not anyone and everyone, but
if you take that position, that's not going to be a winner.
Well, it's those who meet the very clear test in Rule 24A2. And the magistrate found that. He made that determination that looking at the fourth criterion, whether there is adequate representation by an existing party. Existing party. This court must construe existing party to not render the term existing superfluous. You have a duty to give effect to every word in a statute. So existing parties means those at the time of the lawsuit. And at the time we filed, or at the time of our application, and at the time we filed, the only existing party defendant was the county.
Well, if you consider Shaka's interest, how does your interest diverge from Shaka's?
In two ways. First of all, my clients represent interests that, first, they all share the ultimate goal, right, of having or seeing this initiative invalidated or upheld to defend it. And they work to support that process. But they also went beyond that. In their motion, they showed how they have very direct personal interests, harms that are suffered by children on Molokai, and that's very critical because, as mentioned in the Riddy Declaration, the impacts on Molokai are different from the impacts on Maui. Molokai is the island where this industry first seized upon in Hawaii decades ago. It is where 75% of the appellees' operations are concentrated. That's, I think, 2,700 acres versus just 700 on Maui. So these people, these residents on Molokai, on this island, that leads a very rural lifestyle, they have the longest and most profound experience of living, again, and this is in the declarations, of living and working next to Monsanto and Dell's fields. So they would offer perspectives that Shaka might not, that the county definitely would not pursue. Secondly,
I guess, though, if the issues are, as you've been sitting here, right, and the issues that the cases were decided, have to do with federal and state preemption and all of those issues, how would the things that you're talking about really make a difference in those legal issues? Because whether the ordinance, stand or fail, depend on these legal issues. They don't depend on the things that you're stating that have an emotional tenor to it. I mean, these are strictly legal issues.
That's not the test for intervention. The test, or the reason why parties approach the court.
Well, but you just said, but you just said that you both share the interest of making sure that these ordinances stay in place. That is your core common ground.
Yes, but that is not the end of the inquiry. And this is in this court's Southwest Center for Biological Diversity, that if we can show we do not have sufficiently congruent interests, then we should be allowed in. And we did show that because we have more narrow interests, again, looking at the specific harms suffered by the Molokai residents, but we also have broader interests. Center for Food Safety has a nationwide organization, as you well know, a nationwide organizational mission. They have years of legal experience litigating in this very type of action, indeed against the very same appellee, Monsanto. They also bring
So you think you would have a better lawyer? Is that what you're saying?
Of course, I don't want to comment on
Well, I think the question is, I appreciate the fact that you have different and more specific harms. Would you make a different legal argument?
we would, our arguments would be different.
In
What
what way?
legal argument would be different?
I can't, all I can say, and respectfully, is that our arguments would be different. And of course, we were just relegated to amicus status, where we had just 3,000 words before the district court and just 7,000 on appeal. So
But
we
this
would have
is your
made
opportunity to make your argument as to what your legal argument would be.
the reason, and again, respectfully, the reason why I'm just limited to saying that we would make different arguments is because I'm not in a position to Monday morning quarterback.
Yeah, but wouldn't this be the time and place? But wouldn't this be the time and place if here you're trying to convince us to say we're not adequately represented by just allowing the intervention of Shaka, because we would make these legal arguments that they have not made?
No, and that is because you are to assess our intervention motion at the time we applied, not to see what happened afterwards and then make us come forward to explain how we would have done things differently. It's, you look at when we applied.
I understand that. I'm just moving ahead to that argument. I understand your argument that the district court should have assessed it on the basis of the existing parties when you made your motion. But moving ahead, that's why I'm saying what the magistrate judge did was to assess your position vis-a-vis Shaka, and that's what I'm trying to discern whether or not, given that decision, whether you would make different arguments than Shaka. And you said you would. The question is, can you articulate those today, or you prefer to rest on the arguments made in your amicus brief?
Well, again, I don't think it's on us at this stage on appeal to then come up with arguments that we would have made. But at that time, given the fact that Shaka had intervened and the only identified interest that they pointed out was twofold, being proponents of the measure and then being plaintiffs in a state action. But our application was different. It was narrower because of, again, these very specific harms that the Molokai residents suffered, and also broader because of Center for Food Safety, its organizational mission that expands nationwide. So that is enough to suggest that our arguments would have been different. And it's not now on us, year and a half later, because we're here on appeal, because our motion was denied, to then pick apart how we would have done things differently.
But if you ask us to get to the merits of the intervention order, we need to analyze how your interests would have been different in the litigation and how you were not adequately represented. So I guess if I were to make the best argument for you, I guess what you're saying is you were not adequately represented by the interests because your members have allegedly suffered unique personal harms by GMOs, including contamination, pollen transfer, and exposure to pesticides. Is that your argument here?
That's one of them. And then also because there's no way that Shaka could have represented Center for Food Safety's organizational mission. And also, I want to point out, Shaka, at the time they filed an application, also filed a motion to dismiss. They wanted the court to stay and to abstain. Right? They had an abstention argument, which would mean that the state courts would have taken over. That directly contradicted with my client's right to be heard in a federal forum, to have their rights adjudicated in federal court. So that was more than enough proof to show that we met that fourth criterion with respect to Shaka. But again, we don't get there because the correct interpretation of Rule 24A2, existing parties, means we only had to prove that the county would not adequately represent our interests.
Well, but what exactly, I want to know, what are you appealing here today?
We are appealing from the district court order, and if I might, I'm sorry, Chief Judge, I forgot to mention earlier that I had hoped to reserve 5 minutes of my time for rebuttal, and I see I'm moving into that now.
That's right. Yeah.
Thank you.
What exactly are you appealing? You're appealing, as I understand it, the district court's order not to rule on the magistrate order?
Yes, we're appealing from the district court's order in which it did two things. First, the district court found that, or judge found that she did not have jurisdiction. Second, she found that even though she wasn't going to touch the magistrate's order, she told us, to save everyone the waste of time and money, that she would not grant our motion to intervene. And she said, ER 10 in her order, 3 critical points. She wanted to stop us from wasting time and money. She had reviewed the record, and she would find that Shaka adequately represented our interests. So she didn't get at the legal burden of proof question of whether existing parties means all other co-applicants. But that's an issue you still can address under your discretion to address issues not passed upon below if you're faced with a clear legal issue and a fully developed record. Here you have both.
Go ahead.
I'm sorry, but I just have a question in terms of, why didn't you file a motion for reconsideration before the district court?
Actually, well, at that point, we could appeal, but
you could appeal, or you could have filed a motion for reconsideration, and you did neither.
But with the district court, or I'm sorry?
Yes, when the magistrate judge, who was then able to rule on this approved consent, made these rulings, you disagreed with the ruling regarding the motion to intervention, correct?
Yes, when the magistrate judge.
Right. Well, Shaka was allowed to intervene, and there was no longer consent for the magistrate judge to proceed as a district court judge. Is that correct? Okay. So then it got assigned to a district court judge, correct?
Yes.
At that point, it seems like you could have filed a motion for reconsideration.
Well,
and you didn't.
Essentially, we went to the district judge for relief. We asked her to treat the magistrate's quote-unquote order as a finding and recommendation, and this is pursuant to New York Chinese TV, the Second Circuit court case that we are asking you to adopt that approach. And
the problem with that is it has consequences for the district courts and magistrate judges all through the circuit that are completely apart from this case. So we don't have any circuit authority, probably, but that's a tough leap, I think.
Well, you do have circuit authority. All of this circuit's precedents on the contours of the Article 3 right to an Article 3 judge, Anderson, Allen versus Meyer, where this court has stated consent is the touchstone of magistrate jurisdiction. That was the actual reason that the circuit court said that the consent of intervention applicants is required. Because of the
Does it say consent of the parties? Does it say consent of the parties?
It does. We're talking about the statute.
So you would ask us to say that an intervener is a party?
Yes, because you have to construe the statute to comport with Article 3.
So how do you, as from a practical standpoint, everyone that wants to upend something then could file a motion to intervene, and it could be 5 years into a litigation, and then you would say that if it weren't going well, someone could do that, and that they're an intervener, and you make them a party, and then it tips over to another judge.
We're not saying that it would apply.
Well, no, but what you're asking the court to do by construing an intervener to be a party, that becomes the capability of that. And if, you know, most of us didn't just fall off the turnip truck, and people, when a litigation isn't going their way after a very long time, that would be exactly what someone would do. So you need to give us a legal authority of how intervener equals party.
And the legal authority is the Constitution.
Well, but the
Your
Supreme
interve-
Court has spoken on this issue in the case of Einstein, and has said that a party is not consistent with what your view of a party is. And the party is one by or against whom a lawsuit is brought. And that doesn't include the intervener. So just struggling to find the legal authority that would countervail what the Supreme Court has said on this.
And I see that my time is up. May I please answer?
Please answer, yes.
Thank you. And the legal authority, again, is this circuit's jurisprudence on the Article 3 right, that it's a personal right. In fact, in Pacemaker, the seminal case in which this court upheld the constitutionality of this very statute, 2 statutory safeguards were named. First, that the district court would be supervising and maintain control over the magistrate system. And second, litigant consent, that this consent belongs to or the flip side of consent is the waiver of a constitutional right. And in Pacemaker, that's why the Article 3 judge is even, or the Article 3 right is even waivable. It's because it belongs to the person. The person going to be bound by the magistrate's order, by the magistrate's decision, must be the person consenting. And that's why the rule that we're asking for today is that you construe 636C parties to include intervention applicants, and specifically intervention as of right, where we are asserting a right to be in this lawsuit. There's a world of difference between interveners as of right and every other person, such as the people that the district court named, like the jurors and witnesses. A world of difference, because they are not going to be bound by the judgment, they're not asking to be bound by the judgment, and they do not have a stake in the outcome.
Thank you, counsel.
Thank you.
May it please the court.
Hello again.
Hello again. Well, I'm happy, of course, to discuss the merits of intervention if this court likes. They're really not before the court. Judge Mulway correctly determined that any appeal from Judge Curran's order denying intervention had to go directly to this court, because Judge Curran was...
Couldn't she have construed it as a motion for reconsideration?
I don't... Your Honor, interesting question, I guess.
I think she could have.
She might have had that ability to do that, but of course...
I don't think the parties asked, but I think she could have.
The parties didn't, and she didn't. It's an interesting question, I agree, but she didn't. And the interesting thing is they had...
Also, too, couldn't you, if, you know, a lot of motions pop up again during a litigation, and if, say, someone could renew, because things change sometimes. You can, like, for example, motions in limine, you rule one way, and then something happens in the trial, and then someone renews it, and you go, whoa, you're right. Or something has happened, someone's opened up an issue on direct that now something becomes relevant on cross that maybe couldn't have been introduced before. So it seems that when she took over this, if it were phrased in a certain way, she could revisit it.
I think she could, Your Honor. There's no question about that. I mean, but what actually happened, of course, is that they simply appealed to her as though it had been a report and recommendation, which it wasn't, and I'll address why. But at that point, she told them, look, I don't have jurisdiction here. Jurisdiction for an appeal would have to go to the Court of Appeals, and she expedited her decision on that in order for them still to have time within that 30-day period after Judge Curran's intervention decision, in which they could have appealed to this court. Even having been given that suggestion, that hint, and that time, they chose not to appeal to this court within that 30-day period. They instead waited past the end of that 30-day period and only appealed to this court, the jurisdictional order of the district court of Judge Mulway. Now, Your Honors have already discussed with your questions a bit why Judge Kern didn't need the consent of a putative or would-be intervener. The plain language, of course, says parties. But more than that, as Your Honor suggested in the Eisenstein decision, the Supreme Court discussed the difference between a third party who would like to be a party and somebody who actually is one. In terms of the pacemaker decision, which was quoted by my opponent, Judge Kennedy, in that case, talked about the party that's being spoken of in 636C as a party to the case or controversy. That's, of course, not what a putative intervener is, but there's even a case that's, I think, more on point for this court. In United States versus Real Property, and that case involved actually the owner of property that was being sued in rem, and that owner had yet to file a claim or an answer to the in rem complaint. And how the court analyzed it is the court said, look, party for purposes of 636 means a true party to the litigation, someone who could file a Rule 60 motion after the judgment. And they said, because this is not a party in that sense, someone who could file a Rule 60 motion, a party to the litigation, they are not a party within the meaning of 636C. That holding applies here as well. A putative or would-be intervener is not a party to the litigation yet. They can't file as such a Rule 60 motion. They're not a party within the meaning of 636C. Because they weren't a party within the meaning of Rule 636C, consent was not required. Any appeal from that decision would have had to go to this court, and it wasn't done timely. So there really is nothing for this court to decide other than the jurisdictional ruling was correct in this case.
Well, let me ask you this, though. What if the court, just for hypothetically, if we were to hold that once the case had been transferred to the district court, it did have the authority to review the magistrate judge's intervention order akin to a motion for reconsideration? If we were, this is hypothetical, can we affirm on the ground that the motion to intervene was properly denied? Or if so, what's your best argument that Shaka adequately represented Mom Huey's interests?
Your Honor, I don't even think you get there yet, and I'll be happy, by the way, to address that question. I'll address it next, but I don't think you'd get there because all you'd have at that point was a recommendation from the magistrate judge that the district court then hadn't acted on. In fact, the district court said, I'm leaving that alone. I'm not touching it. So you don't have a decision that on the merits could even be appealed to this court. This court would have to remand back to the district court and have the district court decide it in the first instance. The district court quite clearly didn't do that. Well,
except Judge Mulway said, well, she kind of double-barreled it. She said, I don't have jurisdiction, but even if I did, I've looked at everything, and I don't find any merit to your motion to intervene.
She said something slightly different with due respect. What she said is, to the extent that you're tempted to file a motion for reconsideration with me, I don't think that I'd grant it because at this point, Shaka undoubtedly is an existing party to the litigation. Whatever your arguments were before.
She never, if I could interrupt, she never looked at the question brand new like Judge Curran did.
That's exactly right. And so I think there would have to be a remand back to her for her to be able to look at that question new. This court is not in the habit of deciding things truly as a court of first or of original jurisdiction. And in fact, it can't do so here because this is an appeal that's up to this court under the collateral order doctrine. And under that doctrine, the court can only hear issues that have been dispositively decided below. That's the Stringfellow decision from the Supreme Court.
So what are you saying is before us right now? What is on appeal?
I think the only thing that's on appeal is whether Judge Mulway correctly decided that any appeal would have had to have gone to this court. I think she decided that correctly. There was no appeal to this court.
She showed her cards on how she might decide it if she were considering the first instance, but the jurisdictional appeal is the only thing in front of her.
I think that's right, and I think that's all that this court has. To the extent, Your Honor, that you asked a question about the merits again, they're not here, but a couple of points there. Number one, first of all, it's not that this was sprung somehow unwarily on the putative interveners. They actually had at ER 149 and 150 in their initial intervention motion before Judge Curran, they addressed the differences between themselves and the folks from Shaka and talked about why they should be at least as good or be included in the bunch. Their analysis of that issue actually is ignoring the established case law of this circuit in the following sense. This circuit holds that if the two different parties that you're dealing with have the same ultimate goal in the litigation, there's a strong presumption then not to allow the intervention. There's a three-part test that is then applied to see whether that strong presumption has been met. Number one, whether the party that's an existing party will undoubtedly make the arguments of the putative intervener. Here, as this court found when it asked questions about the topic, there's been no point at which the putative interveners have said that have identified any argument on the merits that wouldn't be made by Shaka, but which they would make. Number two, that they're ready and able, willing and able to make such arguments. Again, there's no basis on which to argue that Shaka is not ready and able. And number three, that there isn't some unique element that is added to the litigation that's absolutely necessary, and they've identified none. Their only point is maybe they would differ on strategy and tactics to some degree, but that's nowhere near enough to meet the test, as this court has held over and over and over again. So, on the merits of that, I don't think they've got a strong argument, but once again, that's not before this court. This court really shouldn't and can't reach that question here.
Thank you, counsel.
You're welcome.
We'll give you 2 minutes to rebuttal.
I first want to start with responding to a case that was raised. I believe it was the U.S. versus Real Property or the Lido Motel case. And the court should look very carefully at footnote 3. And there, aside from the party question, the court did intimate that if the property claimant had perfected standing by filing a claim at the same time as the 60B motion, that the district court would be empowered to then decide whether to grant the complainant some relief, even though he was absent at the initial stage, did not make an appearance, did not become a party, that later he was still not precluded from access to the district court, to the judge. So I think that case actually supports our position, and it is in line, again, with this circuit's precedents in all of the Article 3 cases that we've cited, that say the touchstone is consent. The touchstone for magistrate jurisdiction is consent. Also, to correct something I stated earlier, I think there was a question posed about the delay or just frustrating, the process. And I want to remind the court that that's exactly what occurred here, that an intervener is a party because if someone is allowed to intervene, even 5 years down the road, they do get to decline consent. That's what happened, and that's why you cannot accept the Seventh Circuit's construction of 636C, because it leads to nonsensical results. Congress could not have intended to give a non-Article 3 judge the discretion to decide whether one is entitled to an Article 3 judge, and it also could not have intended what happened here, which is to have parties adverse to my client's interests, the county and the plaintiffs, for their decisions to dictate whether we had access to an Article 3 judge. Also, I want to point out that we're faced today with the threat of having no one defend the GE initiative, which because of, as you'll hear in the next case, the pending motion to dismiss for Shaka's lack of standing. And to the extent that this court, again, to the extent that this court finds any merit with that motion, the magistrate judge's error in this case becomes all the more glaring. So we are asking you to allow us in, give my clients their rightful day in court. Thank you.
Thank you, counsel. Case just heard will be submitted for decision, and we'll proceed with the final case on the morning's oral argument calendar, Tay versus County of Maui. Wait just a minute while we... proceed.
Good morning, Your Honors. May it please the Court. My name is Bernie Bays. I represent Shaka, which is a Maui community group with over 500 members and several of its individual members. My clients are interveners as a matter of right in the federal action, and they are the plaintiffs in the state action that was removed to federal court. As you know, in this case, the district court struck down a Maui ordinance that was passed by the Maui voters in a general election through the initiative process. The ordinance was passed to address serious health, environmental, and economic concerns arising out of the extensive genetic engineered crop industry within the county of Maui. Basically, the GE crop industry had grown out of control on Maui, and there was no end in sight. I would like to point out that this ordinance is the only ordinance that has been passed by initiative since the initiative process was added to the county charter in 1983, over 30 years ago. I think this underscores the importance of this ordinance to the people of Maui that I represent. I think it's unquestioned that this ordinance is a valid exercise of the broad police power that has been delegated by the state to the county of Maui. And I paraphrase, to enact ordinances deemed necessary to protect the health, life, and property of its citizens, which is exactly what this ordinance does. This also means that this ordinance was enacted for legitimate public purposes, and that this ordinance is a reasonable approach to achieving those purposes.
Are you going to be speaking on federal preemption?
Yes, I'm going to be forced to handle both state preemption and federal.
I wanted to ask you a question on, in this case, the procedural posture is a little different than the other case in the sense that Judge Mulway, my understanding is, found both express federal preemption and implied federal preemption, correct?
That's correct, Your Honor.
Can you tell me the difference in the implications of those holdings?
Well, I think there is no implied federal preemption where there's an express preemption provision in the Plant Protection Act. As you know, she struck down this otherwise valid statute on two grounds: state law preemption and federal preemption under the Plant Protection Act. And the Plant Protection Act has a specific express preemption provision in Section 436.
Well, I guess what I'm asking you, say, for example, if this panel were to hold that only express federal preemption applies, would the ordinance be facially invalid or only invalid as applied as to plants that are regulated under the PPA and have not been deregulated?
Well, I think there's only the express preemption applies. There is no implied preemption.
Well, but she said implied. But she said implied does. So I'm trying to ferret out how that differs in the actual application of things.
She said that, and that was wrong. And I think we just looked at the.
Let's just assume she's right. Just forget the procedural down.
Okay.
Okay. What would that mean if she is that there is federal express preemption and implied federal preemption? How would that play out?
Well, I think what that would do, and basically what the appellees ask the court to do in this case with regard to federal preemption, is to overrule this court's decision in Vilsack. As you know, the court in Vilsack carefully and narrowly defined the scope of the Plant Protection Act to regulating plant pests in order to avoid harm or injury to other plants. This ordinance does not do that. This ordinance is a land use ordinance operating only within Maui County. And its objective is not to control plant pest harms, but to control public safety, environmental, and economic risks that result not from a plant pest, but from the farming activities and practices that are being engaged in. So there's no effort by the county to regulate a plant pest. And if you would like, and I could take a minute, I could run through some of the harms that are addressed by this ordinance. And as I do that, you'll see that none of them are plant pest harms that fall within the scope of the Plant Protection Act as defined by this court in the Vilsack case. Would that be helpful, Your Honors?
Well, I think we understand the harms you allege, but if it's your time for oral argument, so if you want to take us through that, fine. The difference in this case and the other cases is that we have an applied preemption holding. And so that would be most helpful if you could address that, because I think we understand the express preemption and the state arguments.
Our position is simple on federal preemption, Your Honor.
Well, but implied federal preemption would reach more things, wouldn't it? I mean, it would really,
it's our position, Your Honor, that this is very simple. And the recent case decided by the Supreme Court said that. Where there's an express preemption provision in a law, that's the definitive expression of congressional intent as to the scope of preemption. There's no need to look beyond the express preemption provision. And the express preemption provision in the Plant Protection Act defined the scope of preemption even more narrowly than the court in Vilsack defined the scope of the Plant Protection Act.
Well, I guess, okay, if we do an express preemption analysis, with respect to the express federal preemption issue, do you agree that the ordinance seeks to control plants that are regulated by APHIS as plant pests under the Plant Protection Act?
No, makes no effort to do that. All this ordinance does is regulate farming operations and practices within the county of Maui, and the public health, environmental, and economic issues that those create. It does nothing to regulate plant pests. That's the responsibility of the U.S. Department of Agriculture and APHIS. And as was pointed out earlier, the U.S. Department of Agriculture, in its brief in the Vilsack case, specifically said that the regulation of these kinds of public health, environmental, and economic concerns were beyond the scope of its authority under the Plant Protection Act. And it specifically said that those kinds of harms should be regulated by the states and local governments.
Okay, but...
And we agree with the U.S. Department of Agriculture on that point.
You're arguing, you would like for us to, did you say overturn Vilsack? Is that what you said?
No, that's what the appellees are asking to do, is overturn Vilsack. I agree with Vilsack completely. I think the analysis by the court in that case was exactly correct as to the limited scope of the Plant Protection Act. And what they held there is that the Plant Protection Act addressed only plant pest harms to prevent injury or damage to other plants. That's the scope of the Plant Protection Act. And the court specifically said in Vilsack that these kind of public safety and environmental harms are beyond the scope of regulation under the Plant Protection Act. Specifically, they discussed transgenic contamination, which is one of the harms that we seek to avoid with this ordinance. They also said increased herbicide use was not a plant pest harm and should be regulated by local government. They also pointed to the development of super weeds as another harm that was not a plant pest harm. And the court there said that those were beyond the scope of the Plant Protection Act. And the express preemption provision in Section 436 even more narrowly defines the scope of preemption in this case. And I would be happy to take a look at those with you if that would be helpful to the court.
Well, now, okay, but I think you're saying that Vilsack just controls this, but when I look at Vilsack, and of course I'm sitting next to someone that I think had something to do with it, it expressly did not address the noxious weed risk under the PPA. It was confined to plant pests other than noxious weeds. So it would follow that the PPA, as interpreted by Vilsack, does not necessarily seek to address different types of harms than the bans at issue. So I'm not sure. I'm not sure that the two can't be that this can't be harmonized with Vilsack, but I'm not sure that Vilsack. I don't know that I read it the same that you do.
Well, Vilsack did discuss the words noxious weed, which appear in the first element of the express preemption provision in the Plant Protection Act. And what the court in Vilsack concluded was that the U.S. Department of Agriculture had never designated a genetically engineered crop as a noxious weed, and that they designate specific plants as noxious weeds.
The issue presented in Vilsack was different, whether APHIS erred by refusing to consider transgenic contamination in deciding to deregulate Roundup Ready alfalfa as a plant pest, right? Isn't that what the issue was?
Yes, they had deregulated it as a plant pest, and they discussed the scope of the Plant Protection Act in doing that. And again, with respect to noxious weeds, they concluded that the U.S. Department of Agriculture and APHIS had never designated genetically engineered plants as a plant pest and had not regulated them under the Part 360 regulations, which deal with noxious weeds. But they had instead dealt with them only as a plant pest within the Part 340 regulations. So the court in Vilsack basically said that noxious weeds were irrelevant for our purposes here today.
You're down to about 2 minutes. Do you want to reserve?
I'd reserve those for rebuttal. Thank you, Your Honor.
One more time, Your Honors.
Getting a workout today.
It is a pleasure, truly. I'm going to be addressing the federal preemption express and implied, at which point I'll be splitting the argument with Ms. Bronster, who will be discussing the standing issues in the case, as well as some wrap-up on state law preemption. In terms of federal preemption, I'd like to start with one thing, because I think it's been a bit confused today. Vilsack had nothing to do with crops that were still under regulation by the agency. It had to do with deregulated crops. And so any statements that were made in that case about what APHIS's authority was or wasn't to prevent harms or alleged harms such as cross-pollination wasn't at issue. It's very clear from the regulations themselves. Again, if you look at Part 340.3 and Part 340.4, it's filled with requirements for the notification process and for the permit process that crops not be grown close together, that there not be inadvertent mixing and all of that. All of that is going to the alleged cross-pollination issues. In fact, we cited in our brief at page 42 and at note 8 a fact statement put out by APHIS, where APHIS discusses, among other things, how it does its field tests. And what it says is that it oversees field tests of GE plants through its notification and permit processes to ensure GE organisms and their progeny do not escape or persist in the environment. Companies must submit all plans for field testing for review. The program only approves those applicants with the ability to adequately confine regulated articles within field test sites, etc. I mean, the whole program is to prevent the dissemination of these plant pests until or unless it's decided they're not. So of course they've got that authority to prevent that harm, and of course they address it. In fact, permits tend to be hundreds of pages of long with stock full of isolation distances and the like. In terms of the express preemption for a moment, counsel, with due respect, was sort of mixing up Supreme Court precedents. When he said that if there is express preemption provision, you can't have implied preemption, he was referring to the Supreme Court's holding in Cipollone. That was a long time ago. That aspect of Cipollone has been overruled by, among others, Geyer, Freightliner, and Spritzma. These cases are discussed at page 34, note 12 of our brief. It's quite clear under current law that regardless of whether there's an express preemption clause, you can go on and look at whether there is implied preemption as well.
That's what I want to know in terms of that. What more do you get out of an implied preemption finding?
Thank you, Your Honor. There's two aspects to it. Number one, as to regulated crops, the ones that are still under regulation, it is an argument that doesn't give us more, but even if this court were to disagree with express preemption, implied preemption would cover those crops under regulation. And I think that argument is actually very straightforward and very compelling.
When you say regulated crops, what are you?
What I'm talking about at this point are GE crops that are being grown pursuant to permits or under the notification procedure of APHIS. So it still considers them to be plant pests. It's still regulating them as plant pests. The companies are field testing them, et cetera.
If they deregulate it, then implied can...
Then implied would be a broader remedy, exactly. If implied preemption applies to deregulated crops, it's a much broader remedy for us against this ordinance. In other words, the ordinance would be knocked out in its entirety. As to regulated first, the reason why you've got very evident conflict or obstacle preemption is the agency wouldn't be able to conduct its program under the methods that it's chosen to do so if states and localities could simply say no field tests. I mean, the agency comes in and says, yes, you may have a field test. That's both to advance the interests of agriculture, but also very clearly so the agency can use the results of that field test to determine whether it has continuing jurisdiction over that plant.
Well, in this case, though, doesn't the existence of the express preemption clause defeat your obstacle preemption agreement?
Not at all.
Argument, rather?
It just complements it, Your Honor. In other words, the fact that there's an express preemption clause we think covers all of that turf already. But if this court were to disagree, you'd still have obstacle preemption. And as I've noted, the Supreme Court has held now time and again that the presence of an express preemption clause doesn't affect how you look at implied preemption.
Well, but I think you look at some Federal Register statements that you quote in your brief in support of your obstacle preemption argument. Are they consistent with the scope of the express preemption clause?
I think they are, Your Honor. I think they're at least...
Or is it your position that these statements go further than the
Well, I was going to say, Your Honor, you put your finger on it. They are at least as broad as the argument, as the express preemption clause would go. Because what they hold essentially is that when APHIS has crops that it is dealing with under its regulations, states can't add to or have different from regulations of these same crops. And so that certainly covers the turf that's covered by the express preemption clause. We think it goes further. We do believe that implied preemption covers deregulated crops as well.
But, agriculture has always been the subject matter of states and counties and all of that. Give me some examples of the other areas where you have this implied federal preemption. Is it like banks, or where is it this broad? I mean, give me some other...
Well, let me put it...
You're asking for something really broad here.
Your Honor, I'm not talking about field preemption, just to be clear here. We're still in the realm of conflict preemption, and so it is my duty and my burden to be able to explain what interests of the federal government are being frustrated in order to justify implied preemption of deregulated. I've already explained why state regulation of regulated crops would frustrate those programs. As to deregulated, and I think that's awfully compelling, as to deregulated crops, the answer is that you've got a statute here that quite expressly in 7701, Congress's findings are that the smooth movement of enterable plants through the United States is critical to the U.S. economy and should be facilitated to the extent practicable. What the agency has done, and that provision also, 771, also provides that the regulations have to be done on the basis of sound science. The agency has taken these instructions from Congress and, acting within its authority under Congress, has established a scheme, a science-based scheme, where it determines over a multi-year period, subject to rigorous analysis, whether these GE plants have harms that are different from the conventional plants from which they originated. If they don't have harms that are greater than that, they are deregulated. They're determined not to be plant pests. What the county is doing here, at least in part, is coming in and saying, we don't buy it. We don't trust what the federal government has done. We want a redo. I mean, obviously, it's just a flat ban, but even to propose a modification of that ban, you've got to do what they call an EFIS, which is like an EIS or an EA, incredibly in-depth, and you've got to redo the analysis that APHIS already did, again, at least in part. And if you look, for example, at the ordinance of Section 7.3F, they talk about horizontal gene transfer from GE organisms between organisms of different species may occur. That's one of the things that they say that has now got to be done under the county's EFIS. Well,
That's what I'm thinking is maybe it doesn't make much of a difference here, but in a published opinion in 9 states on the Ninth Circuit, it could make a big difference if implied preemption is found.
In terms of its precedential value,
yes.
Your Honor. There's no doubt. We don't think that we're acting outside of precedent in this case, so we don't think that this court would be taking an additional step.
What other case has both express and implied preemption?
Well, again, the cases that I cited before from the Supreme Court, where you've got Freightliner, Spritzma, and Geyer, are all cases where there were express preemption clauses, and the court went on to consider implied preemption as well, and referred back to its statement in Cipollone that you couldn't have both, and said that that's wrong. And the reason, actually, when you're talking at least about conflict preemption, makes a lot of sense. Congress can't foresee everything that a state or a county might do that could frustrate the federal plan or what the agency is seeking to accomplish, particularly when it comes to agencies.
And you talk about Congress, because there is a presumption that whatever is beyond the scope of the express preemption provision was not intended to be preempted by Congress.
No, I don't think there is, Your Honor. I don't think that presumption has outlived the cases that I've cited. But in any event, what we're talking about here, of course, is preemption by what the agency is doing. And we have to look there to the City of New York versus FCC case, the Supreme Court case. At that point, you're not looking at congressional intent to preempt anything in particular. What you're looking at there is the county, in this case, acting within its lawful authority and promulgating its regulations. That's the first question. The second question then is what the, not the county, was what APHIS is doing something that it has lawful authority to do? That's the first question. Here it does. There's no dispute about that. The second question then is what the state or county is doing going to frustrate the accomplishment of what that agency is doing? Now, that's not something that Congress, often will foresee, because it doesn't always foresee everything that an agency is going to do under its lawful authority to promote the programs. So you have to look at conflict preemption as well as express preemption, and certainly states and counties aren't allowed to frustrate what federal agencies are trying to accomplish within their lawful authority. Again, that's City of New York versus FCC.
So you're saying there's express preemption and then implied conflict preemption,
yes,
but not field.
Bingo. That's exactly it, Your Honor. That's our position. I'd like to reserve, if I could, the remainder of my time to Ms. Braunster. I see I've taken some of hers.
Very good.
And I apologize for that.
Thank you.
Thank you.
Well, now I get to say good afternoon.
Yes, indeed.
We've been at this so long. I want to touch upon a few things with respect to state preemption that I think were somewhat confused this morning. and that is the fact that the argument seems to be that if the legislature did not say that the counties couldn't do it, they can. And that simply disregards the manner in which our state government is set up. Under the Dillon Rule, we have a situation where the counties are only allowed to do what has been specifically delegated to the counties. So it is not a situation where you're just sitting there and everyone can do everything as long as it's not prohibited. It's exactly the opposite. And so what you have to start with is, where is the authority to regulate in the area of ag? And I believe that Article 11, Section 3 is critical to the beginning of the analysis as to whether or not there is a comprehensive scheme. And I think both Judge Curran and Judge Mulway got it right in this regard. Judge Curran said that the idea that there may be police powers or the public trust obligations does not get around the fact that the state has a comprehensive regulatory scheme for regulating pesticides and GE crops, which, together with the context of the statewide constitutional concern for ag and the administrative structures in the Department of Ag and the Department of Health, evidences intent that state law be uniform and exclusive. And the Constitution said the state shall conserve and protect agricultural lands, promote diversified ag, and the Constitutional Convention showed that diversified ag included GE, increase agricultural self-sufficiency, and assure the availability of agriculturally suitable lands. So we start with that proposition, and then it says the legislature shall provide standards and criteria to accomplish the foregoing. And when the legislature set up the very elaborate schemes, it was consistent with how the state operates. Hawaii is an incredibly centralized government. We have no townships, we have no towns. We have the state government, which covers everything, and we've got 4 counties. And historically, we have not delegated tremendous regulatory authority to the counties. I mean, we have a statewide school system from kindergarten all the way up through college. Our community colleges are statewide, run by the state. The Department of Health, our hospitals, everything is centralized. So when we talk about having the Department of Ag have these people come in from the counties, it is to advise the state as to how the state is going to regulate, not as a way of delegation. Judge Callahan, you asked earlier about the question of whether or not 194, which had a role for the counties, was a delegation.
Right. I do have a question that how can we hold that state law impliedly preempts counties from banning GE crops when the state law, including, I think, Section 141.3 and 194.2, clearly recognize that counties may control plant pests?
Well, I think what it says is that they can come in and work with the state. The way the system works is the Department of Ag calls upon people from all over, the Department of Tropical Ag, the university, county players, and brings them in and says, let's figure out what we should be doing on a statewide basis. And then 141 specifically says, and then the Department of Ag should go to the legislature to see whether there are additional things. But it is a centralized aspect. It is not a statute that says, okay, counties, you go regulate. That's not what 194 does, 141.3 does. It deals with the centralized aspect.
Well, it seems, though, I think that when we were discussing, is your case more like Ewing or more like Citizens Utilities Company or whatever? And it seems like maybe it's more like Ewing.
Well, I think the reason that it's distinguishable from Ewing is that in this case, the counties are simply relying on broad police powers. And those broad police powers are, within the statute itself, restricted not once but twice. Their police powers say, subject to the general laws. So if the state has general laws and the Department of Ag, I think that's already a limitation. And then the police power says also they cannot regulate where there is a comprehensive scheme or conflict.
Give me a practical application of how it plays out for you if the court were to hold there is express federal preemption, there's not implied federal preemption, and that there's not implied state preemption. How does that play out for you?
Well, I mean, if the court were to rule that way, you would be changing fundamentally the way that the state government has operated throughout its history. You'd basically be giving counties rights to regulate in areas that they've never been regulatory bodies. If you look, for example, at the veto message in Kauai, the mayor said, this isn't our thing. If you look at the county here, the county has not even appealed the ruling, and we'll get to that in a moment if I have time. But I think that it would fundamentally change things and give counties areas of regulation that simply have never existed.
Well, what about though, is there, I'm always looking for easy ways every time you talk about preemption, but what about the county ordinance penalty provision that violates the charter? If that's in violation of the charter, does the panel even need to address preemption?
Well, actually, we believe that there are multiple areas in which the ordinance violated the charter. Not only the penalty provision, but
I'm just asking you specifically. If the panel were to find that the penalty provision violates the county charter, does the panel need to address the preemption issue?
As long as the panel found that there was no ability to sever. And if the court...
That's my question. So
yes,
is there ability to sever?
I don't believe there is an ability to sever. And as I mentioned, so if the court believed that it violated the charter and was not severable, that could be the end of the story. And we don't need to reach anything else. But we believe that you cannot sever because the penalty provision was part and parcel of the entire ordinance. And as Judge Mulway said, you may be able to look at part of the severance, but the civil penalties is another problem that you have. And then, in addition, there are other charter problems that this ordinance had, including that the initiative attempted to place a limit on the role of the county council, and whether or not, how long it would take for the county council to be able to modify or repeal the statute. So there are many problems, and we think that without looking at all of them, you could never sever and try and slice and dice it, because you'd be stepping in and trying to rewrite the entire law, and that is not allowed. So you can get rid of the Maui ordinance with respect to the county charter issues. There are county charter issues also in Kauai, which the court never reached. But we believe that if you could also eliminate the entire law by looking at the state preemption issues.
Our questions have taken you over time.
All right.
Do you want to summarize?
I have one more question.
Go ahead. Hold on. Let her summarize what she wants to.
What I wanted to also raise was our motion to dismiss. And I know I have very limited time here, but we believe that the Shaka should not be able to proceed because they came in here as proponents of the law. Hollingsworth made clear that as proponents they did not have standing. And we believe that they are more like the plaintiff in Diamond, where they're attempting to pursue the appeal simply to force the government to pass a certain type of law. And we don't believe that they have that right. And finally, under the Lujan test, they have not asserted an injury in fact. Instead, their injury is general to the population at large, or it is purely conjectural and hypothetical. GE plants and the parties here have been together for decades in Maui, and yet they have not asserted any specific injury or established any specific injury that would be redressed by allowing this ordinance to go into effect. For example, A lot of what they're saying is that they are troubled by pesticides. The Maui ordinance is not a pesticide ordinance. So we believe that their ability to show standing when the county has chosen not to appeal is something that they cannot meet. And actually, this court could strike down or just simply dismiss this appeal and not reach the merits that we've spent so much time talking about.
Judge Callahan had a question.
The thing that if once a GE crop is created with a plant and is created with a plant pest, once it's been deregulated by APHIS, it's just like any other crop then, right?
Then it is treated as presumptively another crop.
As far as the PPA is concerned?
Yes.
Okay. So based on your argument of the state preemption, then they couldn't ban then they wouldn't be able to ban these, if it was deregulated, then they still couldn't ban them. Is that right?
That's correct. If the court adopts the federal implied conflict preemption, the state could not do it. But if either the court does not agree or you look at other aspects of regulation that wouldn't potentially be conflicted, then our position is that it's the state that has the exclusive jurisdiction.
Okay.
Thank you, counsel. Rebuttal?
Thank you, Your Honor. I'm going to start out by agreeing with a statement that was made by counsel. He said that the whole purpose of the Plant Protection Act is to prevent dissemination of a plant pest. I agree with that. It's the responsibility of APHIS in issuing these permits to prevent the dissemination of a plant pest. That's APHIS's job. We assume they're doing a good job on that. Our job as the County of Maui is to regulate land uses within Maui County and to regulate the harms that can be caused by those land uses. That's exactly what this ordinance does. It does nothing to interfere with APHIS's responsibility to prevent, and I quote again, the dissemination of a plant pest. So that's the limitation of the authority of APHIS according to this court in Vilsack. So that's its job. Our job is to regulate the farming practices and farming operations within Maui County. And historically, the regulations of those kinds of practices have been done in Hawaii at the county level, subject to general parameters established by the state. So historically, that's the way it's been done. To spend just a moment on the state preemption issue, which has already been pretty well beat to death here, what the state could do or might have done is not what's relevant here. What's relevant here is what the state has done. And the reality is that the Attorney General has said that there are no state statutes regulating genetically modified crop farming in Hawaii. And as a practical matter, what's happened is that the regulation of GE crops in Hawaii has been left to the counties. And this county by county approach to regulation of GE crops in Hawaii makes a great deal of sense, where the counties are separated from each other by big stretches of open ocean. So farming practices in Maui County are not going to have an effect in Honolulu County. Also, county by county regulation makes sense because each of the counties have different land use goals and objectives. So it makes sense in Hawaii to do what we have done, and that's that the state has not regulated genetically modified crops, and according to the Attorney General. And I think we can expect that if there were the kind of statutory scheme that was intended to be comprehensive, uniform, and exclusive, that the Attorney General of the state of Hawaii would know about it. He said there are no such laws. And as you can see, laws have been introduced at the state level to regulate GE crops. None have been passed. The reality is that this has been done on a county-by-county basis. And I think in Hawaii, that's a sensible way to do it. The case I was referring to on express preemption versus implied preemption is the Franklin case. And in that case, the Supreme Court recently said that where there's an express preemption provision in the law, that defines congressional intent as to preemption. And what the court says is Congress does not hide elephants in a mouse hole. In other words, if Congress has an intent with respect to preemption, it includes that in the express preemption provision. So we look to that exclusively to define the scope of preemption that was intended by Congress.
Thank you all for your arguments this morning. It's very interesting and important cases. I want to thank the audience for their attention. And the case just argued will be submitted for decision. We'll be in recess for the morning.